All right. If everything went according to plan, we should be live at the moment.
Yeah.
And today with us, we have Sean is back and Ron is back. Ron, you haven't been here for a while. What's been going on with you?
Oh, it's been crazy since my son's wedding in December. Catching up with deadlines and having all kinds of excitement, and thank God things are beginning to stabilize so that I can once be completely upended when Passover comes.
Well, good to know. Well,
these are what we call white people's problems. Okay.
Well, okay. I used to listen to Ben Shapiro quite a lot, and I came up with the observation that there seem to be more Jewish holidays than any group in America.
Well, any group that you're aware of. I mean, we have more holidays than people realize, and we have a lot of kind of quasi festive things that keep us busy in a religious vein, but which aren't off the grid days. But it is an action-packed life.
All right, Sean, what's been going on with you besides your mute button?
Not too much, just trying not to freeze to death. It's been very busy, just doing work in the real world. And yeah, I learned about all these Jewish holidays once I got to law school. My professors started like, we have this day, this day, this day, and I'm like, I didn't know there were so many. So
yeah,
it's also congratulations to your son, Ron.
Thank you. That's my last one. We are now empty nesters, which in our lives doesn't mean all that much because the kids come home almost every Shabbat. In other words, the couples rotate through. We have not yet turned our house into an ocean liner, which is what most people with money do. But it's, thank God, we see them a lot, and we see our grandchildren, and we're happy that they're making their own lives. We're not going to be replaced.
Oh, fair enough. All right. Well, speaking of somebody who will not be replaced, apparently showing up at court today to follow up a story that Nate and I have covered a couple times, sometimes with the panel. I think, Sean, you might have been on one. The illustrious Don Lemon is appearing in court today for his arraignment. There's been a little bit of news since we last covered. From what I understand, one of the, I guess I'll say, co-defendants, or I'll just say one of the other people charged, had apparently flipped on Don Lemon, saying no, he, as a matter of fact, was active in the planning and helping us, etc. So I don't know if that is going to change anything or not. Nate, do you have any knowledge, thoughts, or comments on this?
Yeah, so he did a video recently where he just came out today. So there have been two updates. Obviously, one, this is the Washington Post. They compared the Don Lemon indictment to the actual video, and they're claiming that this part in the video where Don Lemon is talking to parishioners going outside, that contradicts the indictment that said that he was blocking people from entering and exit the church. And the reason why this is supposed to be important is because the FACE Act, you need force, threat of force, or something like that. And they're saying that this clearly contradicted it. So
that's one of the two charges. He's also charged with the Klan Act, right?
Yeah, but the Klan Act, but it's kind of the Klan Act also is about going and trying to protest, and the issue with that was his intent. So let me read the notes because I did have notes. So the issue here is that the factual allegations in the indictment that Don Lemon physically obstructed and confronted Congress hold up against the video evidence. Now, obviously, we just talked about the Rule of FACE Act, and right now, with the indictment, the issue, the tension is the prosecutorial theory versus the facts. Did the DOJ rush the indictment without reviewing the basic evidence, and is holding the door open? Would that be considered physical obstruction, the element of the crime needed for both the FACE Act and likely a component needed for the Klan Act? And at the end of the day, do you think there's probable cause that Don Lemon actually violated this law? What say you guys?
Ron?
I think we need to know facts. Right now, we don't know enough facts. If he just showed up and said, "Wow," or even if he, I suppose, from what I understand, I'm not entirely comfortable with this, and listeners should realize, if they don't already, Ron Coleman has never been, and wishes he would have been, a criminal defense lawyer. Okay, but having said all that, if he sort of joined the procession and said, "Oh, there's going to be a newsworthy event, and I'm going to be, I'm going to report on it," then I think we're going to need a lot more facts before we're able to say that this is a legit prosecution. Well, it might be a legitimate prosecution, but I remember there are two questions, right? One is this a entire? Of course, it's politically motivated. Is it an entirely politically motivated and abusive prosecution? Question one. Number two, even if it's an illegitimate prosecution, would he be convicted? And as of right now, it's not obvious to me that he would be convicted. And the question of whether it's a legitimate prosecution, I guess, is going to depend on what we end up learning that the U.S. attorney has. So to some extent, these are obviously they're not the same question, but they're quite closely related.
Well, Ron, you are not a criminal lawyer, as you just stated, but I believe you are a First Amendment lawyer, and a lot of the claims with this case are First Amendment claims, I believe, from Don Lemon.
You mean defense? His defense.
Well, I said Don Lemon, but yes, I mean claims from Don Lemon, the defendant, about his free speech. Does this actually depart from free speech, as far as you know, or not, from that angle of your specialty?
If there's a crime, then we talk about whether or not there's a defense, whether his conduct was privileged.
Okay.
First, I want to know whether there was a crime.
Okay.
Well, but let me just finish the thought. If in fact it's politically motivated, that's more of a problem in a case where he was involved in First Amendment activities.
Here's a hot read of what happened. It's from Inside Edition. They put together a nice little 1 minute, 36-second summary of things. So this may just help us move forward.
There's strong reaction today to Don Lemon's arrest.
The Trump administration taking new aggressive steps against journalists.
His former colleagues at CNN expressing outrage.
This very much has Trump retribution vibes.
The White House responding with mockery, announcing Lemon's arrest on social media with the caption, "When life gives you lemons." He was taken into custody early Friday morning in Los Angeles after attending a pre-Grammy party. According to one report, he was seen being handcuffed while flanked by FBI and Homeland Security agents. Lemon is here in Los Angeles to cover the Grammys for his YouTube channel. He's scheduled to be here at Crypto.com Arena on the red carpet, interviewing celebrities before Sunday's show. But all that is up in the air now that he's in federal custody.
I'm just going to walk in, see what's happening.
It was this report 2 weeks ago that landed him in hot water with the Trump administration. He followed anti-ICE agitators into a Minneapolis church whose pastor is believed to work with ICE.
I'm not part of the group. I'm just here photographing. I'm a journalist.
But the White House claims he was one of the organizers. And today, Attorney General Pam Bondi says a grand jury indicted Lemon on charges that he interfered with the congregant's civil rights.
If I haven't been clear already, if you violate that sacred right, we are coming after you.
Don Lemon is planning to.
So now, just a little bit more technical background on this case. They first took the facts of this case to a magistrate judge to get an arrest warrant. The magistrate judge declined to that there was probable cause against Don Lemon specifically because they said that there was no intent. They couldn't prove that Don Lemon intended to go into the church to protest. His intent.
When you said they didn't prove, what's the level? You just have to
show probable cause.
Right. In order to show probable cause, you immediately need to meet a burden of coming forward, right? There has to be a prima facie good basis to believe. It's not the same as it's not even a burden of proof. It's a burden of here's what we've got. Here's our snapshot.
Yeah, it's probably best to say more likely than not. That's essentially probable cause. Probable cause is more likely than not. So the judge, in finding that the magistrate judge at the initial hearing, finding there's no probable cause, essentially said that the intent element was missing because Don Lemon repeatedly said, "I'm not going to protest. I'm going to cover a protest." So that intent element, Sean.
No, but this is where, once again, I mean, I think Ryan Mullally was right when he brought it up. Changes to Alex Jones wandering around an abortion clinic and asking women, what do you think it's right you're murdering little babies? I'm just asking questions. Like, but you're not. You're not. And you can say I'm not part of the gang. I'm not part of the conspiracy. But, when you're having a joke and a smoke with the people doing the thing and you're involved in all their secret planning and all the gay ops they're putting together, it looks like you're part of the conspiracy. So
I mean, it can't be, Nate. I think we've been left with, we lay people have been left with I think a false impression that if a guy just says, or maybe a guy just says, "I'm not committing a crime here," then that meets the prosecutor. In other words, that's enough to negate the prosecutor's claim that he's doing a crime. That can't, obviously that's not the case.
Yeah, I don't mean to make it sound that way. If I made it sound that way, that absolutely not. What I'm saying is that generally, the probable cause hearings I've been through, the judge is going to look at the totality of the circumstances to see, what all happened, and again, could we achieve probable cause? More likely than not, that a crime has been committed, and this person has committed that crime, and you just generally go through the elements. In this particular case, in going through the elements, number one, we were talking about foreknowledge. I think we brought up foreknowledge in the federal courts doesn't matter. If you know that someone's going to commit a crime, you don't have the obligation to report that. You don't have the obligation to turn the person in.
Felony.
You have nothing. So foreknowledge is obviously not enough. Now, in this case, Don Lemon did have foreknowledge they were going to do this. He talked about it, blah, 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 blah. So that you would also put. So foreknowledge is not enough. The second thing that you need to find out is was there any overt acts? I know Sean knows this stone cold, where an overt act in a conspiracy, me opening the door for the bank robbers to come in. That would be an overt act, and then will we charge with the aiding and abetting? Here you don't have that because Don Lemon waited for them to go into the church and start protesting before he went in and started doing his thing.
Now, as a juror, I'm sorry, Nate. I thought you were finished.
And then the last piece is the intent element, which is the one that really came down to. The intent was the judge was looking at the intent from the totality of the circumstances. There were parts in the video where Don Lemon said, we're going to go do this. We're going to go do this. But then that's contradicted with all the parts where Don Lemon before, during, and even after the situation kept saying, I'm not going to protest. I am going to cover it. And then end the church. I'm not one of the protesters. I'm just here covering it. And then afterward, he kept saying, I'm not part of this. I am protesting. And not only was Don Lemon arrested, but all the other journalists who were there also with the foreknowledge were arrested. So that seems to be the tension here. Ron, you're about to say something. Go ahead. Sorry.
I do think the fact that he remembered his lines during certain parts, but didn't remember his lines during other parts. Not only does it not help him, it might hurt him because, I mean, what I was going to say was if I were a juror and I saw those opening, I guess I'm just going to go in and see what's going on down there. It really comes across as phony.
Yeah. No, he knew. Just to be clear, they discussed.
Yeah, but he sounds all folksy when he does that. Like, I heard there was something happening. I just came, and all these protesters were having a hectic protest.
Wink.
Yeah, it's very much. It's a lot
all
like
the denials. Like, when does a reporter at the site of an event usually find it appropriate to say, "By the way, I'm not one of the protesters"? Like, when do you see a reporter do that?
Why would you specify? Why would you feel need? Right. It's like, that's almost an admittance. I'm sure that some could interpret. Whereas if it's just a reporter and they're just reporting, they wouldn't have to sit there and go, hey, remember, folks, it's like General Walker when JFK was assassinated. I know this is a deep cut, but General Walker was going up and down a plane at the time saying, my name is General Walker. Remember, I was here. My name is General Walker. Remember, I was here.
Which you can watch on America's Untold Stories.
Well, I think you have I think the issue cuts both ways, though. I think it cuts both ways because you do have you're trying to elicit someone else's intent. And in one instance, we're trying to do it by actions and conduct, which you can do. But then you also have admissions and omissions. And I think in this particular case, when it's so muddy, and we're also talking about a fundamental First Amendment right, because the church was open to the public, he didn't break in, and so he was there, and other journalists were there too. I think when it cuts so close, the courts, as in Minnesota, they really, really are going to be more protective of journalistic rights in the First Amendment rather than say this isn't. Because again, what makes this different? Like Eric always talk about what makes this different than an embedded journalist with, let's say, sex traffickers that Vox does all the time, and so these other things where they do have foreknowledge.
But there's an answer. There's an answer to that. First Amendment rights of the church goers and the pastor are what are being infringed here. Mm-hmm. So the First Amendment issues balance out, and then I think what happens, Nate, is all you've done is identify defenses.
Yeah, that's what I'm saying. Yes,
and I don't understand. I mean, I might understand, but I don't think there's really a good faith basis for the magistrate to say, I'm going to adjudicate that defense by not signing the arrest warrant. I mean, I think the government came forward with a prima facie case. He says, okay, I mean, I imagine there are going to be some defenses here, but that's what Don Lemon has a lawyer for. I don't see how he doesn't sign. Sean got a big smile out of Sean. What do you think, Sean?
Yeah, it is why he's got a lawyer, but I also understand the standpoint of like them saying it's kind of like what some of the things the DOJ has done, where they make these claims and they're walking stuff back. And I don't think Don Lemon obstructed anybody there. But clearly, he was with a group of people, including that one guy, the woke farmer guy who was going around and basically telling people, like, touch me and you'll see what happens. Like, he was clear, and that's part of the problem is when you saddle up with a bunch of bad dudes, it's like Lonesome Dove, when they have to hang their buddy they find. God, I feel like a boomer citing that movie. But it's a really good point. Like, I don't know if you guys have seen that before, but, they're a bunch of cowboys and one of their buddies goes off and joins a gang of guys who are murdering and wrestling cattle, and he's like, I was just hanging out with them so I didn't get killed traveling across territory. And they're like, that's probably true, but we got to do this. And I don't buy Don Lemon's arguments of, and like Eric said, when you have to keep saying, hey guys, remember, I'm not part of this. Well, because people are obviously going to think you're part of this. But once again, I bring up to the idea of even a court, if they support this or allow it to keep going forward, we're just seeing jury nullification out the wazoo.
Oh yeah.
Everywhere we go. So I don't know if they even, at the end of the day, it's going to go anywhere.
So here are some clips so I did a video where I took what the government said, it took the exact clips where you found them. And then, so we'll play them so we can all get the context of what the government's saying, particularly is the crimes that are being committed. So this is the one that's involving intent, where Don Lemon is going to say all this stuff about, how he knows what they're going to do, that type of thing.
Our resistance protesters, they're planning an operation that we're going to follow them on. I can't tell you exactly what they're doing, but it's called Operation Pull Up. And it's Takima Armstrong, and she has been doing this since George Floyd, Dante Wright, and others, where they surprise people, catch them off guard, and hold them to account. And so that's what we're doing here. And then we're after.
Go ahead.
That sounds like he's taking a definite side. I'll say that much.
Yeah,
and has knowledge of exactly what is going to happen.
We're going to hold them to account.
He has definitive knowledge, in my opinion, here that they are going to violate the rights of those other people in the church. Is he not describing it? At least he may not know the law, but it does sound like he has knowledge that what they are being charged for, they are going to do, and he knows this ahead. Am I correct in my observation?
I think that's astute. That's extremely correct, but I'll say this. Under the law, it's irrelevant because foreknowledge of the criminal activity does not mean you're a co-conspirator. You need to have the agreement, the overt act.
But this is where, yes, Nate, you're right.
It's the overt act and go ahead.
Yes, it's one brick.
It's one brick.
We have a bunch of other bricks here. Where
So I
he's
just want
like-
to make sure it's just alone
yes,
doesn't really
yes,
mean anything.
No, but you should point out every single thing along the way, correct?
Yes,
Like
right,
Sean said,
correct.
that is a
Yes.
legitimate brick.
But Nate is right. One raindrop is not a flood.
To that, after we do this operation, you'll see it live and use these operations as surprise operations. Again, can't tell you where they're going.
So it seems like there's a so they have an agreement, but now this is where the judge said the agreement may not hold up because what is the agreement for Don Lemon to cover the event? Don Lemon agreement to cover their protest, or is his agreement to go in and protest? If
Question,
it's to go in and protest,
Nate,
then that's the violation.
can we slide the super chat in here because I think it's on point? It's on the judge. Why not talk about the magistrate judge's wife working for the state attorney general who stated publicly he would not have made a prosecution?
I'll tell you why not to talk about it. I think it's interesting, but I don't actually think it goes. It's a separate topic. Like, we're trying to analyze what is the rationale. Can the decision by the magistrate judge be justified? And then the question of whether we have a reason for believing that he was biased is a separate, like.
Or how about if he should even be making the decision? If he has a conflict, should he be making that decision? So should that not be from the get-go? Like, first, are you qualified to do it? As in, are there no conflicts, etc.? So I think that's relevant.
Procedurally, you're right, but now we're post facto. So now we're looking at the decision. Here's the point. Here's the point. If the decision was legit, like if we all agreed, or a reviewing judge or panel or ethics committee would agree that there doesn't seem to have, maybe there was even, it would have been appropriate for him to recuse, but it turns out that he made the right decision and we're not going to lose our heads over it. We need to know post facto, was he right or was he wrong? And if he was wrong, then I'm not saying Justin's wrong to ask the question.
Right.
But that's not the part of the discussion that we're in. Yes. I mean, we know this is a problem throughout the federal judiciary. One of the things that's unique to the judiciary, not only the federal, in the 21st century, there are the number of judges who are the sole income earners in their households are few and far between. And this is a well-known problem in government in general, certainly in Congress, for God's sake. And it is a problem in the judiciary. So it's a completely legit question. But first, I'm trying to figure out.
I agree with Ron. Yeah, like, yes, there is a judicial insurgency. We literally have basically any judge who wants to act lawless right now is acting in a lawless manner, and there's not really accountability. This is one of those bricks that goes in that pile. Right now, doing that just kind of drags down. And going after that allows Don Lemon to kind of walk out the back door. You know, we got Don Lemon. We could focus on Don Lemon. We could focus on all these scumbag judges later. So,
okay, whatever. I thought it was an interesting question and part of the overall decision matrix. If you
should not be swept under the table. We have a problem. Yes. It's a problem, and there's a lack of oversight. And as Sean points out, we are in the midst of a nationwide judicial insurrection, and there has been a really pathetic lack of leadership from this on both the Judiciary Committee of the two houses of Congress and of the Supreme Court.
All right, and I have to answer this chat. All four of you are washouts in law. I have to correct you. You are factually completely wrong and off base. I'm not a lawyer.
Only three of us are.
Yeah, only three of us.
Only three of us are goobers. Nice try.
Here is some more of allegedly what the government points to say Don Lemon intended to go in and protest.
Target location establishes a specific clip.
How are you?
Good.
See, we're on. We're not saying what it is, what's going on, but thank you. Tell us why you're doing that.
Now, I want to be very clear. The government says that line that you just heard, we're not telling anybody where it's at. We're keeping all the secret. That shows Don Lemon is part of the conspiracy, and that shows that he's trying to hide the conspiracy from everybody to help facilitate the crime that's going to happen.
Wait, are you saying it's a brick? Is it a brick?
Yeah, I'm saying
good.
this
That's
is a
another brick. Okay, cool.
But I'm still saying, even those 2 bricks. Matter of fact, if we built the house with that 1 brick, it would not be enough.
Yes, it's not a very good house.
Yes, it's not a very good
Right,
house.
but we're 2 bricks
that
now.
brick.
Come on.
Yes,
Yeah,
we're
yeah,
2
we
bricks.
like-
We have like an Eeyore house.
Give me
now.
another brick and we'll start
We got
getting a
2
pile.
bricks.
So come on.
So
This is Nakima Levy Armstrong. She's on the show
Nakima
on
Levy
Friday.
Armstrong, civil rights attorney, longtime activist here in the community. And, we protest and do activism in all kinds of ways. This is Operation Pull Up, more of a clandestine operation. We show up somewhere that is a key location. They don't expect us to come there. And then we disrupt business as usual. So that's what we're about to go do right now. We've had a lot of success with the times we have done Operation Pull Up.
It's against the law. It's against the law. You are allowed to do that in a drugstore, in a movie theater. I mean, you might or might not be allowed, but when it comes to a house of worship or an abortion clinic, Congress has spoken. You can't. You can't.
But Ron, she's a lawyer.
Yeah.
She just said so. She knows better.
Yeah.
So Stephen Weissman.
Yeah.
Now, here is
Andrew
Don
Weissman, I
Lemon.
mean.
Andrew Weissman. Here is right before they start the protest. This is Don Lemon again. The government's saying this is more evidence of Don Lemon trying to further the conspiracy. So they're trying to say these are the overt acts. Him trying to keep the secret, and him trying to further. So this is another thing. The indictment that was signed by the grand jury specifically points to.
Right? No. No. Okay, so we are here now. Do you think if you just have it? I think maybe if you just have it on the church, but if they see me, they're gonna know. No.
It just depends.
What?
Don't name the location.
I'm not naming the location, but I mean, I'm just wondering if you see me.
I mean,
the folks inside see me.
Are the congregants really on live instead of in service right now?
No, but they'll be like, "Why is Don Lemon here?"
So now we got, if he goes in, he's going to spill the beads in, and let everyone knows that, hey, something's about to happen here. Do you guys think that?
I would say that's a brick. Actually, that's 2 bricks. One towards the case, and I'd say a complete wall due to his narcissism.
Well, yes.
Yeah. Here it is from the
I'm Don Lemon. Why is it on here?
So this was it. Yeah, it's interesting because when you put it all together, here again, they point to this and they say, well, now part of the criminal acts that Don Lemon is that this is trespassing because he was specifically asked to leave, and now since he didn't leave, that now is another brick, like Eric was saying. So we have the 2 bricks of the foreknowledge and the planning. Now he's saying this is another brick, the fact that he was asked to leave specifically by this pastor.
Over 20 minutes, he is still screwing around on the property.
And that there's a physical interaction here that the government points to, where Don Lemon crouches to pastor, the pastor kind of pushes him back, and Don Lemon says, "Please don't push me." So they're saying that gives you your force element, even though it's minor. It gives you your force element that it could achieve something for the FACE Act, which requires force in terms of blocking access and such. So here's the clip.
He was also in the he was definitely in his space, not only after he claimed, "Please don't touch me," but he remained in the space of that pastor. Who looked definitively uncomfortable. By anybody who's objectively honest will see that pastor is leaning back. You don't lean back in a conversation unless you're against the wall. If there's no wall there, then that is definitively that he was in his space, or at least he felt that way.
So they name it overt act number 24. While talking to the pastor, if it stood close to the pastor and Lemon caused the pastor's right hand to graze him, then admonished the pastor, "Please don't." So they're saying that was a physical act. So let's go to it and we'll see if they describe it. So here it is. We got to pull it back a little bit. So I'm just pulling it back so we get right at the beginning of the confrontation here. There it is.
Because that's the hope of these cities. That's the hope of the world is Jesus Christ.
I want to be very respectful. Please don't push me, though.
We're here to worship Jesus.
Yes.
That's why we're here.
Yeah.
Okay. That's why we're here. Okay. That's what we're about.
Don't you think Jesus would be understanding
we're about
and love these folks?
We're about spreading the love of Jesus.
But did you try to talk to them as a
no
Christian?
one is willing to talk.
Okay.
I have to take care of my church and my family, so I asked if you actually would also leave this building.
You don't want us to
unless you're here to
chronicle what
worship.
happened?
Unless you're here to worship.
I'm always worship. I'm a Christian.
We're here to worship.
Yeah.
We're here to worship. Okay.
Thank you very much.
Governments. What do you guys think? Are we closer to probable cause with the government is saying? Because like Eric's first brick, the agreement and the qualification. Then you go into the church, then you're asked to leave, then you have the physical contact.
Well, the third brick of hiding.
And the hiding it, yes. What do you guys
You're
think?
up to 5 or 6 bricks now. I forget.
Yeah, I think we're at cinder blocks now.
Well, yeah. No, and once again, a lot of this starts to override because once again, you could be like, oh, I'm just here to film this and, what's going on. But when you turn from I'm asking questions to your, like, I'm telling you their lore. I'm telling you their complete ideology and thought.
Exactly.
And it's you're more of the propagandist. It's like the guy who's filming the Al-Qaeda attack. I'm just documenting it. I'm not doing terrorist propaganda. I'm just filming these guys attack a U.S. convoy. I'm just a journalist. Well, like, no, and and then
how is that
when you go
different
home and
than
edit and you put in the na music in the background. It's like, no, you're clearly pushing that view.
So you're saying he's stepping into propagandist, but then that's freedom of speech too, possibly. I don't know.
Yeah, but you're propagandizing for a side though, and you're their cheerleader and you're their documentarian. Like you're like it's not the first time people have filmed themselves committing crimes.
I agree, but isn't a document? Here's the thing: I don't like Lemon. I'd like to see him go down. But using your analogy, I thought that a documentary, even though every documentary to me is slanted, it's the very nature of a documentary to be creating a case for a side. And I did state that he was acting as a documentarian here versus a standard journalist. But is that not also falling under the First Amendment? I'm going to go to Ron and qualify or ask that.
Can I make a point? You just stumbled on something that I wanted to address before that I wasn't quite clear how to get it in. Standard journalism. Since the beginning of social media, blogging, I used to be very involved. There was a brief time when there was something called the what was it called? The Media Bloggers Association. Robert Cox from the now defunct National Debate blog was very involved in trying to establish the rights of bloggers to be treated the same as journalists. And of course, and this was deemed and perceived as a threat, the same way influencers are deemed as a threat today by regime journalists. And one thing about Don, Don Lemon is almost like a perfect law school. This case is a law school exam. This is and those who did go to law school will also remember the aphorism: hard cases make bad law. And I promise you, this case will make some bad law one way or another. If I'm a journalist. See, I'm a journalist. Oh, what if I have a microphone with a little square around it that says Don Lemon? Does that make me more of a journalist? What if I used to work for CNN? What if I do work for CNN? There's constitutionally, there should be no distinction among people who are reporting on anyone who's reporting on a subject. I suppose it's legitimate to say that we will look to how important journalism is to your life to ascertain whether you really are doing journalism. I mean, one of the things I learned from the great law professor and blogger Glenn Reynolds is journalism isn't something you are, it's something you do.
Yeah. Good point.
And Don Lemon is no more entitled to do things in that church than Nate or Eric or Sean or Ron. Well, in fact, Nate, I think, probably has a lot more viewers than Don Lemon. So, speaking of massive viewership. How you doing, Joe? So it's really important. I mean, it's an issue that is always bubbling under the surface, and we have to understand that so-called professional journalists, whether they're between gigs or not, have no more rights than anyone else to report on matters of public concern. That also means that everyone does have a certain bundle of rights in that regard. But I think, Eric, as you go through these little video snippets, he sure seems less and less like a reporter and more like an advocate. But guess what? Going back to your point about documentaries, it's not only documentaries that have a point of view. All reporters have a point of view. Mm-hmm. So that's why this is going to be a hard case.
All right. Who was that?
If this happened at a mosque, they would have been arrested that day and would still be behind bars. I'm tired of being the reasonable one.
That's right.
Oh, Joe, you're about to say something.
Yeah, I mean, I haven't been here for a while, and that's really because the topics they've been covering for a while now, none of them did I know anything about, and I heard this topic, and I was like, now I come back. Now I come back because this is
Since when has that been a
problem?
problem?
That's what it is, Joe. Okay. Yeah.
This is the one.
He was joking because because it's LawTube, man.
No, I was on holiday and then I was away, and it was just like one thing was just like after another. And then last week I could have come back, but I really didn't know anything about any of the topics you were talking about.
You sound sick. Also,
and now I've been away so long that even though I am sick now, I'm fighting a flu that's starting to overtake me. I was like, no, this is. I want to get back in. I want to get back in here on the regular, and this is. So I got in here as early as I could. This is such an important topic, and it's something I don't think anyone really thinks about. What does freedom of the press mean? How is it different from freedom of speech? It's clearly different. The founders clearly look at it as if it's different. Freedom of the press is different than freedom of speech. But at the same time, we shouldn't fool ourselves into thinking that freedom of the press means something that's objective, because our founding fathers themselves saw some of the most biased and slanted press reporting in the world, and they still saw fit to protect it. I mean, complete straight out lies. During the Revolutionary War, I mean, the Tories would just make up whatever lies they could about George Washington. And we saw later on the election between Jefferson
of
and
1800.
The election of 1800. I mean, they were basically making up the most slanderous, salacious lies, sexual accusations. Jefferson and Adams. It was just craziness. and yet they very clearly valued freedom of the press, and it doesn't seem as if they thought there was a right to condemn the press. So it would not be Don Lemon's biases that would strip him of freedom of the press. I want to make that clear. If you're looking at this as a historical document, as originalist or anything like that, you have to understand that. But freedom of the press, to me, what is that? How is it different from freedom of speech? Freedom of speech is obviously
not according to. I want to jump in because I keep quoting uncivil law, but he made something really clear to me that I didn't understand. According to him, freedom of the press and freedom of speech are identical. The only difference is that press is the mechanism of delivery. So it is truly somebody's speech, but how it's distributed is via the press, and that was that at the time. Same way that if I said something on the internet or I said it in the public square, I can be hit with defamation, and somebody who writes an article can be hit with libel, which is a form of defamation too. So I was like, it sort of makes sense if you think of it as the means of transmittal of said speech.
Right, and I agree mostly with what you say there, or what are we quoting on Uncivil? I'll assume you got him accurately. So what Uncivil is saying there, I agree mostly. I think that it would go a little bit further than that. It's that freedom of the press is that the media, that the government can do nothing to stop me from disseminating. I guess it's pretty much the same thing. That the government is inhibited from stopping me from disseminating my stuff, which means that this is not so what does that mean, dissemination? Does that also mean collation? Does that mean that because over here, when you're collecting it, now it's happening in one instant, which is not what was happening in the time of the Founding Fathers, right? Because in the time of the Founding Fathers, you would learn information and then go to press to share it out there. Now it's all happening instantaneously. I'm reporting it, live streaming it, while at the same time disseminating it to the public. So now we're breaching into this new area that our founding fathers could never have considered, because it was not something that was possible in the 18th century, that you're actually involved in the crime, while potentially involved in committing a crime, while you're also serving as a member of the press in the exact same moment. That's almost impossible.
Well, Joe, did they not for founding fathers time? I want to address your founding father case.
Yeah, go ahead.
Well,
in that time, I was going to say, did they not give speeches at the same time? So a lot of times they would give a speech out loud, public, so you orate, and that same information would be spread around in a pamphlet. Press.
Yeah,
same
correct,
activity.
You're
So,
correct.
that's all. And I'm
You're
sorry,
correct,
Nick.
but
Go ahead.
my point is, you wouldn't be committing a crime in the same moment. You know what I'm saying? You wouldn't be committing a crime while you're up there on a stump giving a speech in the 18th century. But here, he could theoretically be committing a crime while actually serving as a member of the press by distributing.
Why
you know,
wouldn't
because if
you
he
had a call
stands
to
there
action,
blocking
you
someone,
said, take that man down. Go attack him. That would be a crime.
Well,
that would be a crime, but through the form of speech. As far as okay, go ahead. You go ahead, Nate. Go ahead.
I just want to give a one-liner that I think will clear this up. Freedom of speech is your right to express ideas under the Constitution. Freedom of the press protects your right to publish and distribute those ideas without government interference. So specifically, and the conflation generally is that people think freedom of the press is freedom for corporations to distribute those ideas, which it is not. It is the freedom of the individual.
Yes, because anybody can be a journalist.
And there have been cases where people were distributing pamphlets for communists and things of that nature that were upheld to be violations of the Constitution under freedom of the press, and those were individuals. Where freedom of speech is the person at the thing. So that's the fundamental difference: distribution and publishing versus just expressing your ideas. So you could have a case where you have both freedom of the speech issues and freedom of the press issues. So I hope that just kind of cleared that difference up.
I'm not sure it did. At least in my brain.
It's still protecting the same thing. It's the ideas.
Yeah.
It's protecting your ideas from being shared. Is that fair?
But in freedom of speech, you're sharing your ideas also.
Yeah, that's why I said that both are. That's why I said that. It's the
that's
same
why
thing.
they're very easily glommed together. But my point is, what you were describing there was, Eric, with someone saying, "Go get that man and string him up." That would be a speech thing, right?
Right, but you could also have a pamphlet doing it too at the same time. What I mean,
that would not be
saying it's impossible to do at the same time. I'm just like,
what I'm saying is, from their perspective, it was pretty much impossible. So if not, it was pretty much inconceivable. And today, it's very easy to see it happening. They could not have conceived of the internet and be able to share information in real time the way we do today. So that's why I think that it's so easily confused. But I agree wholeheartedly with the notion that Don Lemon is a journalist. Every one of us on this panel are journalists. Everyone you watching at home today are journalists from the perspective of freedom of the press.
Well, Joe even got press credentials, so he's a double journalist.
Oh yeah, you just
well, have press credentials.
Here is this key point. So this is a key point in the Don Lemon scenario. So this at this part, the Justice Department has said that Don Lemon is right now essentially, which we're about to watch, he's going to be analogous to someone who's at an abortion clinic in front of the door, blocking people from entering as they exiting. That's the FACE Act. So what you're about to see is the government's key contention about Don Lemon violating the FACE Act. So here it is. And lastly, they say Lemon was confronting congregants at the door. At one point, defendant Lemon posted himself they tried to exit.
Folks are leaving. Just want to show you, and that's the inside of the church there where they are.
Now, mind you, if he was standing there blocking people from entering or exiting, he's violated the FACE Act. 100%. So now, and this is what the government is saying is proof of the violation of the FACE Act.
And so the pastor, I don't know if you can see in there, the pastor's hugging members of the church as they are about to leave. And so an interesting Sunday morning for you.
Steven,
What do you think of
just
this?
a harmless Christian here that wants to praise the Lord with my son, and now I got to go home. I'm sorry that you guys are so angry.
I'm just
sorry.
chronicling. I'm not with the group.
Oh, what do I have to say?
Can you understand why they're angry?
I don't understand any of this because I'm a simple man. I'm a simple man who loves the Lord and is a good father. So this is what we look forward to, is coming, being with our family and praising Jesus. And that's not something that we have to run away from. So this is kind of a bad day for us.
All right. So that is the government's argument that Don Lemon was essentially blocking access to an abortion clinic or a church. So I'm not sure if you guys think that's convincing or that's
not convincing to me in that regard.
Quite the contrary. He's holding the door open for them.
Yeah.
So yeah, I don't think that's gonna work.
No.
Well, and that's the issue for today. Here is the article. I think I might have closed it, but there's an article today by the Washington Post who's also trying to describe this particular instance, and they're saying that the judge today, they may drop all the charges because they don't believe that equates to probable cause with what you just saw here, and that's why they say the magistrate judge declined probable cause.
It's nice that the Washington Post can still scrape together enough reporters to cover this. It's good.
Wait, Nate, you were saying today that they might drop the case?
Well, that they were supposed to. Don Lemon's asking for the judge to drop the case based on
That's
that.
That's very different.
Yeah. Well, that's what I'm saying. They might drop it. They're requesting it. So that's
okay. I thought you meant like the DOJ's dropping, and it's like, okay, no, then I give up.
No, I'm sorry. That definitely not.
Yeah, you got me.
They're going full in. Here is the Washington Post article, so you guys can see it. And there's this video, the Don Lemon indictment video appears. Oh, let me put this on the screen. Don Lemon indictment video appears to contradict the key claims. And as you can see, they're talking about these two claims, particularly the blocking of the door and talking to the pastor. So that's what Don Lemon, and Don Lemon's, he's gone live, but I haven't been able to watch what he says, but he said it, he's saying it went very, 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 very good for him. Because the arguments, as you guys,
I'm sure it did.
Doesn't seem like
very well.
It made it to probable cause. So now that you guys kind of seen everything, what do you guys take? Do you guys, like, I personally, and I'll just be honest, I think you have probable cause. I think you could easily make probable cause, but I don't think this survives a probable cause hearing where a judge actually looks through this and says, do we have enough to get the trial? I think that's kind of where the rubber meets the road here. But I do think there was probable cause to charge, but I don't think it goes farther than a suppression hearing. What do you guys say?
Let a jury decide it.
I think that's. I don't know if it's going to get as far. Like I told you, what a jury in Minnesota is going to do, in Minneapolis, Minnesota is going to do. But
I think Frey is asking an interesting question. So any journalist can walk into a church, stick a mic in any worshiper's face.
Is this something you can bring up, or
it's Frey? It's comment there. So you guys, so Nate, do you think that a journalist can just randomly walk into a church, stick a mic in someone's face, and start asking them, and just start disrupting them, and in the middle of their prayers because they're covering it, and they're not stopping them from leaving, but they're just purposefully trying to disrupt them while they're engaging? You think under the guise of journalism?
Well, I would say the first thing we do is the place open to public? If it is open to the public, then you can go in. Then just being open to the public doesn't mean you can do whatever you want inside that place. So obviously you have to kind of do with the conditions and stuff. Like, you can't, a courthouse is open to the public, but you can't just go in and do whatever you want. And then the last thing I would say in terms of that is that you would just need more information, because if you do go to a church and they are praying and then you pull out a mic and say you want to start interviewing people, then that I don't think would be a violation of the SAVE Act or a violation of any of these acts. I think if you are protesting and doing it under the guise of journalism, which I think they're trying.
What about the time of this? For example, okay, you go into the church, you've got a microphone, and everybody's having tea and cookies.
Okay.
And they're gathering around, and That's one thing. The other thing, what if they're in the middle of a prayer right now, and the prayer is being recited? You're like, hey, so what do you think about blah, 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 blah? while they're sitting there trying to pray in this moment. I mean, does it matter what is being done at the time? I'm asking that legitimately, because it would seem there's at a minimum an appropriateness problem.
You're talking about well, there's a generally with First Amendment talking about time, place, and manner. So I know all the attorneys here, and then you're also talking about the intent of the person too, because you can have the act, which I think we all kind of agree with, but really we're talking about the intent of the person. If his intent is to protest and disrupt services, which would have to be proven beyond a reasonable doubt, then you have that. Well, I don't think you have that in this particular case, because I think it would be extremely tough to prove beyond a reasonable doubt that his intent was to go in there and violate the law.
Well, he knew that their intent was, for sure. We agree on that, right? He knew completely, utterly that their intent was to violate and interfere with the services. Would that be a fit? No, he did know that. I'm asking the one question, yes or no.
So I'm saying yes, and that goes exactly to the case that we talked about last time. We talked about. I
understand, but
where they foreknowledge again.
I know, but you're now answering what I'm not trying to say.
Okay, go ahead.
Thank you. I'm just saying that the next part that I'm trying to say is that he knew that they were doing that, and now he is actually holding up the microphone on people. And again, time, place, and manner. He already knows that one is going on. His activities could be seen as that as well, in my opinion. That's what I'm asking. I'm just saying that foreknowledge. Hey, we, and he said we, by the way, he took the claim, and he said they too, which further adds to it. So he's saying we as in us together, they, which is a them, which again places him on the other side, is kind of a deputization. And he goes in and he's doing this. I'm saying his actions are disruptive in of themselves. Correct?
And no, I would say no. I would say we're trying to look for like the smoking gun here, right? Like, for instance, you're saying he said we, he said they, and the court's going to look at it. So what? He also said, I am not part of the group. I mean, he said it before, he said it after, he said it during, and he said it even in follow-up interviews. So you're right. He may have said a we or a they, but they're going to cap that with, but he actually said this. And then you have the other people in the group
while he was interfering.
Actually, hold on. You then also had the other people saying the same thing. He was covering the group. And then when he's even interviewing people, he's saying, so I'm saying you can make an argument, which I think you're doing, but I think the facts cut both ways on the other side. The other side has a very compelling argument too. So the same we's and days you're playing, they're going to say, yeah, you can interpret that, but what did he actually mean? What was his actual intent? And his actual intent was, here he is saying it multiple times.
If you're looking for a smoking gun, I don't think it's going to come from any of the video he shot that day. The smoking gun is most likely to come, if it comes at all, through communications or testimony about his role in setting up this entire thing, which I think it's very possible that they are going to find that, because it seems as if this entire thing was staged for the purposes of getting the promotion of being on Don Lemon show, and assuming that if we believe that assumption is correct, I think that Don Lemon has serious problems. If that assumption is incorrect, then I think that the videos we see here probably do not survive a probable cause hearing. That's my takeaway. That if the government's going to succeed here, there's going to be another nugget of information, which basically has them saying, okay, should we go on this Sunday or the week after? When are you going to be able to make it out here, Don? And now all of a sudden, their actions are geared and motivated towards appearing on his show. Yeah, and now that makes him a conspirator in this entire thing.
Well, they have a witness. Supposedly, one of the people involved has said, yes, as a matter of fact, Don was totally in on all the planning. So that could be effective.
Jordan Richardson. Yeah.
Okay.
Yeah.
Well, what is Jordan's statement?
Yeah. What? Yeah. Well, we don't know what his statement is yet. We know that we know he was a producer, and we know that the authorities are talking to him, but we don't know about that yet. So it'll be interesting to see if they end up amending their indictment in order to include him as an additional fact, because he ultimately could be the key here, or some other producer who was there.
Yeah, I think everybody would agree. Any type of coordination about dates and everything, and those are going to be very, very important. And I'm assuming they're subpoenaing all that stuff too. It's easy to get from the phone company.
All right, so should we shift on to the next case? I didn't realize we we're going to spend an hour on this one.
It's a lot. You know what? Because it has a lot to do. But we can move to the SAVE Act. You guys.
Well, not the SAVE Act.
Save America Act.
Save America Act.
Well, actually, no. the Hegseth story.
Well,
I advertised it, so I'm kind of like, let's talk about what I actually said the show's going to be.
I can read it. So the background: Senator Mark Kelly, retired Navy captain.
Yes, and astronaut.
Senator Mark Kelly, an astronaut, and other Democrats released that video telling troops they have a duty to refuse illegal orders.
Yes.
Defense Secretary Pete Hegseth then attempted to censure Kelly because he was and threatened to demote his retirement pay and rank, arguing that it was seditious. So they went through that process. Kelly then sued. The issue came down to, can the Department of Justice punish a retired military officer who is also a sitting U.S. senator for political speech under the guise of maintaining military discipline? Obviously, they were saying that on one side, we're talking about a First Amendment right and separation of powers, particularly that the executive branch's ability to punish legislative branch members for political speech.
I have a weird stance on that. If people want to hear, it might surprise people.
Here is it says so the Pentagon argued that Kelly was subject to the Uniform Code of Military Justice and as a retiree, and that his comments harmed the good order and discipline of the troops. The other side was saying that Kelly is a political, essentially a politician with the other branch of government and has a First Amendment right to share. If you're a politician, you can't talk politics, then what the hell are you doing? So that was the thing. The conclusion: Judge Leon, a federal judge, granted a preliminary injunction blocking the Pentagon from taking any action against Kelly while the lawsuit proceeds, and he ruled that Kelly is likely to win on the merits because he has a First Amendment claim, and that this is obviously political retaliation. So right now, Kelly still has his rank, still has his money, but they cannot. And then they're going to go farther. But they said based on what we have now, it's likely Kelly's going to win.
Okay,
so those are the facts behind it.
This is my thoughts on it, and it might surprise people. I don't think they should be trying to demote him or mess with his pay, because he did a career, and whatever that span was in that career, that was an agreement. He fulfilled that contract, and that contract stated that if he finished all of that, then he was going to get a retirement pay. And I'm going to draw a weird analogy, but like, let's say that he did a full military career, all of that, and then he retired and he robbed a bank. Now, he absolutely should be prosecuted for robbing the bank, etc., but the pension should still be going to his house and caring for his family, because that was something that from his life before, as far as I know from being in the military, that's what I understood.
If those are the rules, then those are the rules.
That's my issue. I think that if there's a case about sedition, then you need to try him for sedition and actually go prosecute him for that particular crime, but not this whole, we're going to go into your rank and change your rank and pay level after the fact when that contract is fulfilled. That doesn't feel quite right to me.
All I would say to that, Eric, is when that whole thing he did, his whatever, all that time, the rules he agreed to play under included this. By the way, as a retired officer, we have a hook in your ass for as long as we deem fit. So
yeah, I don't know. I don't know about that. And
but
I think you'll find precedent.
But I would just say here at the end of the day, they did try to indict these guys, and a grand jury said no. And honestly, I think that's the right answer. Like, we all know what they were trying to do. It was all wink, wink, nudge, nudge, especially when you have two intelligence officers in that video, Alyssa Slotkin and Maggie Goodlander. Two intelligence officers. Like, we all know what they're doing, and they know that we know what they're doing, and they're doing it anyway. It's all wink, wink, and nudge, nudge. So, yeah, it's all First Amendment protected, but are they scumbags, and are they tap dancing on the line? Sure, but they're still not over the line.
What do you think about Kelly's political separation of powers argument? The fact that he is a part of the legislature, it's a political branch of government, and they are punishing him for exercising political and rhetorical stuff for that branch of government. So in other words, the executive is trying to exert this control over their over his ability to legislate in a political branch.
He wasn't legislating right there.
Well,
were we passing a revision of the UCMJ, or
in terms of act in terms of acting. You know, he's presenting a political position.
Well, he's not doing it in committee, Nate. If he said it while he was in Congress speaking, behind the microphone, nobody could do anything about it. He's doing it on X and elsewhere with a letter, right? So that's a little bit outside of session.
Well, what they're saying is, I'm a senator. I'm a political operator. I'm going and I'm saying all this stuff wherever I'm saying it.
Yeah.
Now the executive can't then say, I don't like what this guy's saying, so I'm going to go after him because, again, that's what they're saying. The separation of powers allows you to act in that particular way and not be punished by the executive. So that's the argument that he's making.
Well, somebody's trying to say it's an administrative action by definition.
Yeah, well,
not punishment.
it is.
However, we could probably dig into that a little bit. That's an interesting weasel word thing. Oh, it's administrative action. Well, are the results of punishment? Yes or no? I mean, doesn't that come into effect? And you guys are the lawyers. I mean, I know we can use certain terms, but from what I understand, if the net result is in fact a punishment or punitive, then you call it what you want, but it's still punishment if it's in response to something.
Weasel words are the only words used in DC. Because if you think about it, the 10th, and it's also the 10th Amendment says you can't violate, that the states are free to act except in ways that the Constitution, the limitation of the federal government are to the areas that are designated by the Constitution. And then we have the Supreme Court come out and say, well, you can withdraw the carrot away and use that to control state action. So even if it's not an area that the federal government is allowed to operate, that you can basically withhold funding from them. So that's a weaselly way that they basically are getting the same effect, but using semantics to get around it. So when you say that, what's really happening here to Mark Kelly is essentially the same thing, you're just using semantics by saying administration rather than punishment. That's the nature of how everything happens in DC. So to me, that's kind of meaningless. The real question to my mind is,
Joe, you realize what you just said is no different from the judges who say immigrants who are being denied their due process rights. I don't care what the weasel words are in the law about depriving me of jurisdiction. I'm here to enforce the Constitution. And what's really happening is these people are not getting due process. I mean, weasel words, as you say, yes, weasel words are the currency of DC, but they're also the currency of the law.
Well, I mean, I'm not sure if you're referring to Boasberg. Boasberg has problems in that he's not operating under the law because he's ignoring the law that restricts his jurisdiction, and that a habeas corpus petition must be brought, as the Supreme Court said, in the jurisdiction where the person is being.
That sounds like weasel words to me. Weasel words because how is it? In other words, if the rules that govern the military, and I don't know that they do, I don't know this stuff, but
right.
If the rules that govern the military say, listen, you get to, first of all, by the way, when someone is a captain, the rank of captain is not unless you were a captain of a ship.
They're equivalent to rank.
He was captain of a navy.
Oh, he's captain of a
He is the equivalent. He's an 06, equivalent of a colonel in the army or a captain in the navy.
Yeah, he's not like a captain in the army.
He's a flag, not quite flag officer, or no flag officer.
You get to use that
He's a staff
title
officer, I think,
for the rest of your life.
Yes.
You get to trade on your military service beyond the distance of your getting
of your time serving.
Of your paycheck and your service.
Well, you're still getting paycheck. That's the thing.
on the condition that you don't fuck with the military. Mm-hmm. And here's a guy who said, well, I'm going to make political hay by fucking with the military. So no one's putting him in jail. No one is preventing him from speaking. But the military is saying, you didn't keep your end of the deal. What am I missing?
The counter argument to that is that the deal itself violates the Constitution. And if you're talking about just the hierarchy of laws, the Constitution allows me freedom of speech. So I've signed this deal and I'm going through the deal. And again, this is Kelly's argument that yes, I'm bound by this deal, but that deal administratively cannot violate the Constitution.
Yeah,
and they're
I mean,
violating my
that would have to be
constitutional
the
rights in
argument.
that instance.
That would have to be,
that's the
which is
argument he's playing out.
and that should be a loser argument. The same way we as attorneys abdicate our right to freedom of unfettered freedom of speech with respect to how we're able to talk about the courts. So too, his, and we voluntarily agreed to that. And the Supreme Court has said you can contractually restrict your free speech rights by contract. So that's what you have NDAs also. But I'm saying by your chosen profession that there's a natural abdication of your otherwise unfettered free speech rights.
But that's what's happening here, especially because he has been discharged. So there's different statuses.
That's the thing. But when he chose to stay as a retired captain, he could have chosen a different form. There are different forms he could have chosen when he's leaving the military. He chose this one, and this one has contractual obligations. If he chose a different one,
I don't know. I'd have to see his contract though. I really worry that you could be on that. And I did look it up, by the way, those in the chat, that it's very rarely that a pension is stripped from military. It's not something.
Yes,
that
it is a very. It's a
not something done. And when you fulfill an obligation in the military, like I was in the military, and I had to serve my requirement, right? So then I left the military, but I had something that was called inactive reserves. So even though I was out, I was a civilian, I was walking around, all that good stuff. Technically, for another year or whatever it was, I could be held to the requirements. But after that point, then I was fully out of it, and I could call myself a sergeant for the rest of my life if I wish to. I have no requirement of anything else. I was a sergeant. I left a sergeant. We are done. I can talk all the trash I want. That was a contract. I fulfilled that contract, and I left the military. And I think that that's the issue. If what he's doing is, in fact, seditious or wrong or whatever, I'm saying just prosecute him according to the law by his crime. This is just a way of trying to punish. And yes, I'm going to get into slippery slope, which I know is a fallacy. I don't care. But when you start this kind of crap, we'll expect it to come around on you, whoever's on the right, that, okay, they'll start attacking your pension because of your views. And when you're stating things, it's like, no, you know what? We don't appreciate you talking about the administration, and that is going against your pension, and we're going to start stripping you of rank. So that is the.
That's not what happened. That's not what happened here. What they're accusing him of doing here is not having a different political opinion from theirs. It's telling military personnel to disregard orders. Mm-hmm. That is a direct threat to the way the military works. Well, if we want to have a pissing contest over whether that's what he did, we can do that, but that's not the judge's call on this motion.
The irony is he did say unlawful orders.
Yeah, they parsed it very, very clear. If he said disobey orders, then we're in a different ballpark. But the fact that he said you have an obligation to disobey illegal orders, which for you military guys, I'm assuming is true.
But Eric, let's pause for a second. Let's pause for a second, because I think that your distinction there blows up Eric's argument, because Eric's argument is basically he shouldn't, unless it's something that he gets convicted of sedition, you cannot punish him. And what you're saying is, if he had actively said, if he had gone out there individually and said, the military, I'm telling you now, disregard their orders.
That's different. Yeah.
So if he had said that, you're saying that, but why? He retired. He's done. He's not in the military anymore. Why should you be able to punish him? His freedom of speech.
That's not what I said. That I said that you go after him for unlawful statements. The same as if any citizen,
right,
does it. That is exactly. I mean, I don't give a damn. I'm saying he's reset as a citizen. So if
then you're rejecting the premise of this process. You're saying there should not be
any restriction.
A restriction on, in which case, a court might agree with you, but I don't think it's the law now.
Yeah, the law is the law is. So there's a difference between criminals a lot higher, and I think administratively they're saying if you do this because you've signed up, if you do this and say you don't have to follow lawful orders, then I think that is the administrative bridge too far, and I think that's not protected by the First Amendment. But what they're saying it's protected is that he said you have an obligation not to follow illegal orders, and that illegal orders then takes it from something that is seditious to something that he's just stating a factual claim. Now, the government's argument is that there's really some underlying, there's more to it than just a factual claim. But on its face, the judge is saying, well, is this true? Is this a true statement? Is this what all officers should do? If that's the truth, then you can't punish him for saying that. So saying something is objectively true.
But the thing is that they're saying you're under unique stress now compared to other times, and I believe they said this government is issuing unlawful orders, and that's the factual, and that's thing. So they didn't say those words.
No, they, like I said, they did just enough to wink, wink, and nudge, nudge, and say, listen, we know it's tough out there. We got your back, but just remember, if they tell you to do anything illegal, you don't have to do it. And they also said this in the context of then going on to meet the press saying, as soon as we get power, God damn it, we're going after everybody, regardless of who you were. Orders don't. I was just following orders won't count. So it was an orchestrated move from them, clearly.
But there's an inaccuracy in the law that they're stating, because it's not if it's something that's illegal that if you hear an order that's illegal that you interpret to be illegal, that is not a law that you have a choice on whether or not to follow. You must follow it. It must be manifestly illegal. No, that's the law.
If you believe it's not correct, and you believe that you're
being
ordered to do something,
you get into war crimes problems. Because if somebody said, "Oh no, Joe, you're really stepping on that,"
it has to be manifestly unconstitutional.
No, Joe's right. The whole 100%. What if all of a sudden you find Jesus in a foxhole all of a sudden, and now you say, I think war is illegal now. I think it's a crime against humanity.
You're wrong on the law, gentlemen.
Well, I'll ask Eric.
As were they, because it has to be manifest.
Eric, you were in the army. Do they? What do they train you? Do they train you to follow?
You first report to the Constitution.
Okay,
that's where I swear the oath. No, every soldier swears to the Constitution first.
But not your interpretation of the Constitution. It has to be manifestly unconstitutional.
But you got to define manifest. That's already hold on, Joe. That's an opinion already. So if for example you say go follow this order and it's to execute a bunch of people or whatever it is, we're starting to get into some war crime territory. Now that is a lawful order given by somebody, but if they don't have the facts on the ground, you go, hey, these people are not armed. You can now let me, and you actually. You see that they are unarmed, you still can be prosecuted for following civilians just because you can say, oh, this is an order that was given to me. I mean, that was the whole argument used in the Geneva Convention. That are you going to be a war expert on this, Joe? I mean, let
me ask you a question.
You tell me I'm wrong, and I'm telling you what you're telling me.
If a police officer gives you an instruction on a pullover, you're pulled over for a traffic stop, and you decline to give your identification and driver's license, and he says, get out of the car, and you don't get out of the car. And he says, well, no, I don't have to get out of the car. You know what script I'm describing, right? I don't have to get out of the car because I didn't do anything wrong. Well, no.
Well, I don't understand the analogy because it's not military.
Lawful order. No, I'm a sovereign citizen and I don't recognize the law under. So that
you're not. How is this relevant, Ron? You're talking about a civilian being pulled over by a police officer versus a soldier who is to follow or not follow a legal order. I mean, the status of a soldier is completely different than a civilian to begin with.
Not for purposes of this question, because what you're saying is every person can decide what is lawful based on, doesn't have to be, kill a civilian. It could just be, we're wearing fatigues to this event. And he said, no, I want to wear my dress uniform. Okay. Well, I don't think that's a lawful order. I think my right to self-express.
I'm not saying that.
Why? What's the distinction? Joe's saying it has to be manifestly illegal. You're saying no. I just have to think
But
it's
what
illegal.
is manifestly? I said you gotta get into that word. And hold on. And saying follow you are not required to follow an illegal order, as an illegal order. Now we're going to start questioning on the.
That's wrong. That is 1,000% wrong. This is the point you keep ignoring, Eric, and I never finished this point. That if you want to defend this, if anyone disregards an order, they cannot say I disregarded the order because it was unconstitutional. They have to defend by saying it was manifestly unconstitutional. If they do not say it was manifestly unconstitutional, they just say I thought it was unconstitutional. In that case, that is not a sufficient defense. Their defense must state that, in my opinion, this was obviously unconstitutional, manifestly unconstitutional. That is a key distinction. And they did not tell they told the entire military that if it's an unconstitutional order, and they did not say it has to be manifestly, obviously, that no one can question that this is really unconstitutional, like shooting down a bunch of unarmed 6-year-olds and tell an order like that. That is anything that anyone looks at that and says that's manifestly unconstitutional. So you're saying that no, if I think it's unconstitutional, that would be a sufficient defense. You can say, well, I thought it was unconstitutional. That's wrong. And that's what they told you. That's what these seditious six told the entire military.
Joe, I got to say something. This is just a light touch, but I would like you to go around and interview all the soldiers here. I live in Hampton. We're in Hampton Roads. There's more military here than anyone else. And I'd like to have you go around and ask them what manifestly unconstitutional is, because I'm telling you right now that a soldier is not equipped, to know the constitutional terms. But if you say shoot that man, and they say no, it's wrong, I can't shoot that man, you have to kind of go back in and backfill with the term manifestly constitutional. So I think there might be another possible term for it, like unjustified murder knowingly, or like Abu Ghraib. I don't know, that maybe that's a good example where you're having them march around naked and things like that, and and mess with other humiliating things that any normal person, military, otherwise, would say this is way beyond the pale. That is the problem. So you're kind of laying in the terms, which is great legally, but it is kind of hard for the soldier on the street. So if you say illegal, there is an understanding in the illegal wrong, just flat out illegal. Like if you know that killing somebody or whatever it is, that this is wrong in every which way, it is not right, you're trained not to do this and everything else, and you're being told something contrary to training, it is what it is. And I'm sorry, go ahead, Nate.
I've pulled up the law. Now, I think both of you are right and wrong in certain places. I think Joe is right with some of the terminology, and I think Eric is right with some of the way it's used. So I'll go through the case law. The case law is simple. In terms of what the law actually says, the case is United States v. Cali. And in that case, it was the Lai massacre during Vietnam. Lieutenant Colonel Willie Colley argued that he was just following orders. The Supreme Court rejected his argument and said service members are not protected to follow orders that is, quote, manifestly unlawful, meaning obviously illegal. So if the issue is obviously illegal on its face, then you don't have to follow it. That's your I'm shooting, shoot someone who is unarmed or something like that. That case was also followed up by Little B. Brand, where the Supreme Court ruled that an officer is liable money-wise if he violates a statute. Again, that's manifestly. So manifestly legal standard, what does that mean? That means targeting civilians, torturing detainees, executing prisoners, violating the law of armed conflict. Also, it can be civilian laws, UCMJ, the Uniform Code of Military Justice. Then when it comes to the legal standards that we're talking about, both of you are correct. An officer is doesn't have to know the ins and outs of the Constitution. Illegal is going to be treated under the common knowledge. In other words, do you believe this murder is illegal? But when you get in front of a courtroom, the standard is going to be, it has to be obviously illegal, manifestly illegal. It has to be illegal on its face. So the officer can deny the order, can say, I'm not going to do this because I believe it's illegal. But when he gets in front of a courtroom, he would have to show in that moment that it was illegal. That it was obviously manifestly illegal.
Yes,
it's obviously illegal on his face in that moment. So I think
not just that
both of you are right.
How is Eric right here? I don't understand when you're saying both are right. I don't understand that. The point is that when they're telling them if an order is unconstitutional, they cannot just come in and say the order was unconstitutional. In my opinion, which that's what they wanted. Their whole goal was to sow confusion and to harm morale by having everyone
it's a destabilization operation.
Yes, by having everyone question, well, I don't know if this is unconstitutional. Maybe this is unconstitutional. I don't know if I'm supposed to follow this, and second guess themselves before they actually engage in activity. Rather than the simpler thing is like, look, if this is obviously unconstitutional, don't follow it. If it's not, obviously, there's a presumption that it is. There's a presumption that it is constitutional, and that unless it's obviously not constitutional, you must follow those orders. That's your job. And
how does intent work? How does intent work? I mean, isn't there a term called mind reading?
Well, can I
sorry for joining late. Can I give a gloss to what Joe's saying that might be helpful?
All right, cool. I just wanted to. Well, I'm just going to read what I pulled up.
Hey, Ryan.
There's a difference between I think it might be unconstitutional, which I think Joe is saying, right? You can't say I think it may be unconstitutional. You have to know for a fact. But I think in practice, when the Army teaches you are not obligated to follow illegal orders. They don't say manifestly illegal. They say illegal orders. And I think that's the conflict here. The obviously illegal is the legal standard, but the illegal orders is what they teach the soldiers on the ground. Ryan, go ahead. That's all I wanted to say.
Yeah, and sorry for joining late. I had a brief I had to get off my desk this morning, but I'm glad to be here for a little bit of this. So good to see everybody. The thing that bothered me about the public statements made by, various Congress people was that I get what they were trying to do, but from the military perspective, there is a presumption that orders are legal. And this is written into the military code. It's written into the manual courts martial, right? So if you perform a duty, you follow an order, it's presumed that the order is legal unless it is patently illegal, right? Mm-hmm. And then you, the soldier, are not at risk of being court-martialed for following the order unless it was so obvious, like the example I think Joe gave, like shoot the kids, that sort of thing. On the flip side, if a soldier says this order was illegal and therefore I will not follow it, they have to be right. If they go to the court-martial and it turns out that the order was in fact legal and they said it was illegal and didn't follow it, they get court-martialed. They lose their job. They go to jail.
Yes, so they want that to happen.
Yeah, the law provides a benefit to the soldiers, the benefit of the doubt when they're following orders, but when they don't follow orders, they're taking that risk upon themselves. And as I think someone earlier here said, soldiers are not going to know whether or not the executive has authority to issue a particular strike. That's the murkiest gray area in all of U.S. constitutional law. And nobody knows if the executive has that authority.
Which means it's presumed constitutional.
Exactly.
It comes to the default of presumed constitutional.
What just to finish the thought, what pissed me off about those statements is that they were asking soldiers to risk their lives and livelihoods for a political benefit to their party, but it's very bad advice to give those soldiers. If you were giving soldiers legal advice, you would not give that advice because it puts them at risk.
And that's the very defense they offer. The very defense they offered is we were just telling people what the law is. And they were not telling people what the law is. They were misstating the law. So your very argument as to why this is an okay thing for them to be doing it fails because of the fact that their objective there was to just enlightening the military about the law when they were actually confusing the military about the law.
Nate, did you look at UCMJ or did you look up civilian law?
Because
civilian law.
Okay, what's UCMJ?
Hold on. Anyways, real quick, kind of, Ryan, I don't know if you were here when I mentioned this or in the back. The reason why they want to sow the doubt is because they've said, we're going to hold everybody accountable when we get in charge. We don't care who you were, but if you did it, we're going to hold you accountable. And they're trying to scare, some enlisted soldier into thinking, oh, God, am I going to get hauled in? Because I'll just say I thought I was following orders. And they're trying to scare everybody. So, yes, it's all about doubt. It's all about destabilizing. And it's clear what they're doing. But is it enough? I mean, they tried to indict him and a grand jury already said no.
They're threatening the military that they're going to prosecute them for following these orders. That's what they're essential. That's what's baked into all of that.
By the way, I think that they're scumbags and they're being I believe they're being dirty. Just you're saying, so you understand. I don't like what Mark Kelly did and anything on that, but I just like the term manifestly. Like I'm looking at UCMJ, manifest isn't there anywhere. It's unlawful. It's illegal. Things like that. Joe, don't get there and go, aggravate because I'm
talking about what the case law says. You're talking about what the UCMJ says. I'm saying what the case
because
law
UCMJ
says.
is what's going to be the prosecution for the soldier to begin with.
All the more confusing they're making it for this military because they're not looking up the case law. So they're now explaining to them what the law is and telling them the wrong law. So that's what makes it so terrible.
Well, they said illegal. They didn't say because
hold
on.
I was looking at manual.
Hold on.
Courts,
Let
manual
Article
916.
Let Eric finish this point, and then we'll come right to Ryan. Go ahead, Eric.
Article 92 says unlawful order or illegal order. It does not say manifestly. It does not have the higher regard. That's what I'm saying. A soldier is reporting first to UCMJ in their duties, and then it might be civilian law or it would go above that. I think UCMJ does.
Yeah, I have it. Article 90
does factor into this discussion.
Yes. So Article 90 UCMJ, it starts there. Willfully disobeying lawful orders. They make it distinct lawful orders from a superior commission officer. Article 91, disobeying a lawful order. Obviously, you're going to get in trouble for that. And the Article 92, failure to obey a lawful general order. So in here, the key word is all lawful. They don't use manifestly. So saying you can disobey an illegal offer, which would follow the Uniform Military Code of Justice. The manifestly is a legal standard, but in the actual training materials, it just says lawful.
But the gloss on that, just to give you the additional cite, is in the code is, well, let me get the exact name of it. It's the Manual for Courts Martials. Rule 916D in defenses, it says obedience to orders. It is a defense to any offense that the accused was acting pursuant to orders unless the accused knew the orders to be unlawful or a person of ordinary sense and understanding would have known the orders to be unlawful, that doesn't use the word manifestly, but it brings in this
right.
a similar standard, because what you're saying is, this is what I was saying before, it's a defense to say I was following the orders unless I should have known, because a reasonable person would have known it was illegal. But if you're talking about like the Venezuela boat strikes, nobody, like, unless you're a Supreme Court justice, nobody knows whether or not those are illegal or illegal. Nobody on God's green earth knows that, because there's no law on it. Like we did the whole Korean War without a military authorization. 50,000 Americans died. There was no military authorization. So the idea that a soldier could say a reasonable person would know that this boat strike was illegal it's insane. So they have a defense to anything if they follow the orders, but if they don't follow the orders, now they're exposed.
Right.
Let me Joe. Go ahead, Joe.
No, and the point, and I think, Eric, you're only making my point all the stronger because you don't have a legal background, you have a military background. So you're more in the position of someone who's in the military than I am, right? So now you're sitting here saying, well, if it's I believe the reading, because I read the UCMJ, that if it's something that I believe to be unconstitutional, that I am at liberty. In fact, I have a duty to not follow that order. And that's what they want. They want the military to think exactly like what you just said. And that's not what the law says. So they're trying to, they come in there and say, because the law says it has to be something that anyone would look at and say, this is unconstitutional, not your personal opinion. And the implication of everything they said there was, if it looks to you like it might be, like it's unconstitutional, that's enough. And it's not, the question is not if it looks to you.
I don't think you're being accurate with what I said, but okay.
My only concern here is that I think when we look at the process, since we're all unfamiliar with military law, I think this would, because we're using defenses and things, but I think this is very analogous to self-defense law, which I think we all are a little bit more familiar with. Self-defense is a thing. I acted in self-defense is a defense, but it's a defense that actually triggers a burden on the state to prove that you did not act in self-defense beyond a reasonable doubt, right? The state has to prove that if you say I acted in self-defense, it then triggers the state has to prove that you didn't act and with lawful self-defense beyond a reasonable doubt. And I think this is the same thing here, with the presumption is every order you're given is lawful. Unless, like Joe is saying, unless it's obviously to a common person that is not lawful.
Which
Now,
I just said 100 times. Which I
think
said
Eric
obviously instead of manifestly. I said to a
Correct.
normal person, I said all of this, but I'm being accused of saying that people are saying, oh, I just don't agree with that because I don't want to wear blue today. That's not what I'm saying at all. I'm saying things like Abu Ghraib was obviously a problem.
Yeah, I think we all agree with that.
Don't sit there. No. And I had orders to do that. No. I don't think that would count. And I think you'd be prosecuted. I think war crimes would fall into that as well. I never said that, oh, you know what, I don't feel like showing up on this day of the week because I just don't think that's right. Or I just think you're wrong, Sergeant, because I've had to be on both ends of that. Well, too bad, you could take it up later. But I did not. You're really selling my statements very low in terms of the threshold, Joe. And the examples I even gave were war crimes, Abu Ghraib, and I think I did multiple times. So
fine, but those were all classified as manifestly unconstitutional.
Well, after the fact.
No, not.
Yeah.
But that's
and
the point.
I said that the soldier doesn't understand what the word manifestly is. They just have to know.
You can change
is this in fact
obviously
wrong?
It doesn't matter. It doesn't matter. You can change the word manifestly for obviously or patently. It's all the same thing. So you don't like my lawyer word because you think it's too much of an SAT word. You can go with obviously. It's the same thing.
I understand the word, Joe.
No, I know you understand it. What I'm saying is, I was quoting you the law, and I was telling you that if you want to dumb it down for the lowest military member to understand it, you can say the word obviously.
I'm actually going to say something shocking here. You guys actually are saying the same exact thing.
I think
don't
we
even
agree.
know what you guys are arguing about at this point in time.
Yeah.
Because Joe is obviously right. It's obvious. He just said manifestly.
Yes.
Eric is obviously right because he said it has to be obviously, and now we're arguing about the standards. You guys
because the argument is that we're coming into the word. So, look, Mark Kelly and them, they should not have said that, in my opinion. I think it's disgusting. I think it's wrong. And the whole circling back point is, I was just saying, I don't think they should have the paid doc. But we went into Joe saying, no, it has to be manifest. When they're saying the word illegal, switch it to unlawful, illegal, whatever. They're saying you aren't supposed to follow unlawful orders. Well,
that's not enough. That's
okay.
wrong.
So
That's
doctor
an inaccurate
retirement. So
statement of
take
law.
their retirement away. I do not think technically, and they were very, very clever and nasty in the way they did it. I think all their intentions were foul as can be, but I don't know if you really technically have anything on them.
And clearly First Amendment protected, by the way. Like, I mean, like that, it's not, I don't think that's very tough.
And I'm going to go the other side. Even if you did, I don't think you should take their pay away. I think you should prosecute them for the crime.
I think the 5 out of 6 of them, I think we're not retired members, are not governed by the UCMJ. I think that's free speech what they did.
So this is the true disagreement that we have. On one side, we have that what Mark Kelly says about not file that you don't have to follow illegal orders. Is that enough to violate the UCMJ under just by saying that? Because it seems like what you're saying, Joe, is that he needed to add the obviously word for it to be legally correct. And I think Eric and Ryan seem to be saying the fact that they said illegal and the UCMJ says you only have an obligation to file lawful orders, that then protects Mark Kelly because he's essentially saying what the UCMJ says.
I want to add one thing. The leaving out of the word obviously or manifestly or patently was purposeful, and that's why it was so terrible. That's what made that was. Hold on 1 second. Stop for 1 second, Eric. The fact that the law is that it has to be obviously unconstitutional, and they come out there saying we're trying to teach you all, we want to just remind you all about the law, that hey, the law says you're not supposed to follow these orders, and they purposefully leave out that word obviously. The reason they're leaving it out is because they are trying to sow confusion, so that if you think to make the average military person think exactly what Eric has been saying here, which is that if I think it's unconstitutional, if I have a good faith reason, but it's not obvious, but I have a good faith reason. I think that killing someone that we don't have a warrant to kill them, and I think that's unconstitutional, right? I have a good faith reason to think it. Well, you're governed by the default, which is there's a presumption that it's constitutional unless there is obviously unconstitutional. And they don't say that, and they purposefully leave that out because the whole objective here was to sow confusion and harm morale. That's what made it so terrible. That leaving out that word is what made it so.
But the word's not in the damn UCMJ.
And that's all the more reason they had to say it, because it's not in the UCMJ, and because the word is not something the military.
No,
can
if I
see.
quote the law to you, and then you would say that's wrong because it doesn't have a word that's not even in the law, I'm very confused. Seriously,
Okay.
I'm genuinely confused about that, because you're saying that they left out a word even though he is quoting the law. So if somebody quotes the law,
that's not the law. Every statute is made.
So UCMJ is not
comes
law?
alive by virtue of how courts interpret it. Okay, so according to, in other words, why do cops give Miranda warnings? Does it say anywhere in the Constitution that they give Miranda warning? No, but the law is because the Supreme Court said in the Miranda decision that in order to preserve your Fifth Amendment rights, you have to make a knowing waiver of them. And if you waive, and you can't make a knowing waiver if you don't know what they are, that's the law. That's the law. And
you're not answering my exact statement. If somebody quotes the law and uses the words in the law, and no additive words. And by the way, UCMJ, last I checked, was law, because holy shit, I could go to prison forever by violating UCMJ. That's what a soldier is prosecuted under, is UCMJ. It's very weird to say that that's not the law.
It is the law. It's definitely the law.
So I'm very confused about this. So if somebody says something like unlawful or illegal, and that's it, and it doesn't say obviously, it doesn't say obviously. I'm confused. And by the way, I don't even like what he did. This is what makes me crazy about it.
Anytime a person acts according to a statute, permission given by a statute, it is necessary for that person to know, how have courts interpreted have I actually acted according to the statute or not? It must be that in other words, we need to apply standards to how statutes will be applied and as a practical matter. So it is true he's quoting a law, but he's not quoting the law. The law is, how do courts, military courts, how do courts interpret that statute? Answer: it has to be obvious, high level, not just what uniform you're wearing today.
I gotta agree with Eric here. If you are just literally quoting the law and saying the law says this, and it seems like you guys are trying to put like an extra step to say, well, you have to now go also quote judicial precedent based on this law to make it extremely clear. And I think that's just, we're parsing it too much at that point. If the guy says, here's what the law says,
you cannot simply go. Again, this is like sovereign citizen reasoning. I read a case. I read the Uniform Commercial Code, and the Uniform Commercial Code says that I don't have to have a license. What are you talking about? Every judge will tell you that that's not the case. This is Joe. This is like Torshabal Kapeh and Shibikasaf. This is like the written.
What he's saying is, if you follow biblical law, in that case, when it says eye for an eye, so that means if someone knocks someone's eye out, you should knock that person's eye out. But everyone any scholar who's ever read it understood that it means you get monetary compensation. You don't knock out someone's eye. So if someone quotes you and says, "Hey, you should knock out his eye because it says in the Bible, eye for an eye," they are misquoting the law.
All right,
they're misquoting.
Joe, hold on.
Can I give a hypothetical that might clarify this?
How about one that's on point?
Just let me.
Yeah. I think I got a good one.
Right, I'm going to pass it to you right in 1 second. I just want to say this. We literally had this thing maybe about a couple of months ago when it came to whether Trump was a convicted felon or not. Joe, remember, you read the law, and the law said something very, very specific. And we all came to the wrong conclusion. It wasn't just Joe. I believe I came to the conclusion, and we all did. And then we looked at the law and said the law was something different. The law obviously was something different than we thought it was, right? And he was a convicted felon under the way New York State interpreted it. We all said it was so crazy the way New York State interpreted the law. But just reading the law, you come to a different conclusion, because if you read the law without the court process, Joe is 100% correct. Matter of fact, I would think
that's 2 years ago now.
Yeah, but you're right though. We all
months ago. It's 2 years.
Oh, it's 2 years ago. I'm sorry.
I'm just saying.
But you were right though, and we all read it though, right? Every one of us read it, and everyone else came to that same conclusion. That we came out. The court said, no, you're all wrong. So I think I don't think it's as easy as that, where you would suspect a non-lawyer who say, hey, here's the law, look at the law. It may be right or wrong in court, but I think on the street, and you just tell it, and you're explaining like, hey, this is what the law says. Then I don't think you really can then make the argument that if he goes to court and says something, then that's one thing. But I think on the street at that level, you can't make you can't, that argument doesn't make sense, because even us lawyers are fooled by just what the law says in some instances. Go ahead, Ryan. I'm sorry.
So I think this is actually going to line up with what you said nicely, right? I think the way you interpret the context in which the statement was said is doing a lot of weight in the analysis, right? Because imagine two different scenarios. One, Mark Kelly is at a law school and he's talking about the law governing military actions. And he says, everybody here, remember, you do not have to follow unlawful orders, something to this effect, right?
Mm-hmm.
Okay. I don't think that would strike anybody as like super problematic, right? Now imagine he's in the Situation Room and there's a soldier who's been ordered to push the button to strike the Venezuelan boat. And he leans over and taps the soldier on the shoulder and says, hey, son, remember, you don't have to follow unlawful orders. Oh, in that context, I might have more of a problem with what he did.
Well,
and so then he said it openly to the internet in the context of ongoing military actions. And I think the way people react to it has a lot to do with how much you think he was speaking to those soldiers in that room, in that circumstance. Because the closer you get to him being in the room, the more improper the statement appears.
And Ryan, it kind of goes along with that when he's on TV saying, we're going to prosecute everybody who did something wrong.
Yeah.
You know, that's like, well, what's wrong? Well, it's like the IRS meme. Well, was my order legal? I don't know. You're going to find out.
Yeah. And just to tie into the sovereign citizen thing, at the risk of tying into the sovereign citizen thing,
which is completely out of whack. No offense, but so a soldier is swearing to the Constitution and falling under the UCMJ, which is a direct law. The sovereign citizen. I think that analogy is extremely off base.
But remember that the reason that they're implying that these orders are illegal is that the president doesn't have authorization or power to strike. Therefore, it's a war crime, right? Or it's murder. Imagine if there was like outside the draft office during the Korean War, which by the way, is arguably unconstitutional for the same reasons. There was no authorization, right? Imagine if there was some retired military official outside the draft office saying, guys, before you turn yourself into the draft, remember, you don't have to follow unlawful orders in the context of this whole war is unconstitutional. You know, that we might have a little bit of a problem with somebody doing that in that context.
Well, I'll even agree with you and say that, but in this particular context that we're talking about with Kelly, we'd have to kind of make that leap. And what I'm saying is that I don't think you can make a credible argument that the statement that he made, without all that other context, because that's the way they're going to look at it. It's a statement on its face, something that would generate this. And I think you can make these arguments, but I think on its face, he's just quoting what the law is. Yeah. Even if he's not quoting the background of it and the obviously part, if he's just quoting what the law says, then I don't think you really have.
By the way, I have a huge problem with what he said. I think what he did was pure scumbaggery, and I think he had every intention to confuse everybody, etc. But I don't know if that's necessarily there. And even if it is wrong, this all stemmed way off track when I said, I feel like when he got his pension, he fulfilled his contract with the military for that said amount of money later on. And that was then. And if what he did was unlawful, I think he should be prosecuted directly for that, not going after his pay, which is something that is already done in the past. And I want to keep circling back to my original point, because that was my original point, that he fulfilled his military contract, he fulfilled his obligations, and he got that money. And if he does commit a crime, whatever the crime is, I'm not saying, oh, he's got a pass for life or whatever. I'm just saying then you prosecute him for said crime and you leave the military and his background out of it.
So
you're changing the rules.
Can
you're
I
suggesting a better. You're saying there should be a different set of rules than the ones we're operating under. You're entitled to that opinion, but the rules that we're operating under are, is if you are a commissioned officer and you retire, we've got a piece of your ass for the rest of your life. Those are the rules.
Well,
I don't know that. Anyway,
so this is.
I think that's being argued and just determined right now.
Yeah,
I don't think that. I think this is testing the actual what the rules are or not.
I don't think that's that argument.
I was going to ask about
that's why they gave a preliminary injunction. The preliminary injunction said he's likely going to win. I'm rejecting that rule that you just said.
But he's likely going to win because the thing he said is protected First Amendment. Not
so they're rejecting what you said.
Not
the
like
they're rejecting it.
No, but the rule, the general regime, the general concept that we have, that there is continuing authority for a retired military commissioned officer as to something.
Correct.
To something that's not going away.
If all six of them,
and just as to this statement, the judge said that statement doesn't qualify as just because it's protected. So they've just said what you
okay, but here
was wrong.
Narrow
case.
Well, no, I'll tell you why you're wrong. Because if this had been a case where all six of them had said, whatever, Trump is not supposed to be president, whatever he tells you to do, don't disregard him. If that's what they had said, right? Which all of you would recognize that's not what the law says. That's not what they're allowed to do. If they had said that, I would still tell you that the 5 out of 6 of them should not be prosecuted for sedition. They can't be prosecuted for sedition. They cannot be. And at the same time, Mark Kelly, because of the UCMJ, has a tighter guideline, and he could lose his rank. He couldn't be prosecuted for sedition. He wouldn't lose that, but he could lose his rank for doing that. And that is something that, and the point that Ron is trying to make on one side over here is, you might be arguing as to whether or not he crossed the line. This judge might say he didn't cross that line as to what he's allowed to say, but there definitely are stricter rules about what Mark Kelly could say than what the other 5 of them can say. Now, Eric might not like that rule, and he might think that that's a bad thing to exist, but that doesn't change the fact that there are tighter rules on Mark Kelly than the other 5 of them.
I mean, yeah, if we're leaving the land of sedition, which I think we seem to universally agree, there's the First Amendment problems and and even just the elements. It's just a non-starter, really, legally. But this is not my area. I'm not a military guy, but when I looked it up, I saw 10 USC 1370, which has a number of provisions. But in subpart F, which is the finality of retired grade determinations, it says in 2D, if the applicable secretary determines, pursuant to regulations prescribed by the Secretary of Defense, that good cause exists to reopen the determination of retired grade. Now, I don't know within the universe of military law what good cause for opening a redetermination of retirement grade is. I quite frankly don't want to speak to that because I just don't know. But it does strike me that it is probably a much different standard than we would apply certainly to sedition and also to civilians, because there are probably a number of things you could do as a retired military member that would constitute good cause for reopening your retirement grade that would not be something that a civilian would have to concern themselves with.
All right. Well, we got a bunch of super chats piled up. I think.
I hate to fight and run, but I feel like we finished our debate here. So I was supposed to leave. I need to leave like 10-15 minutes ago. I gotta go shopping.
Nate Dub.
I will see you all, God willing, next week.
Happy Valentine's. You're late.
Happy Valentine's Day,
See you, Joe.
Joe, good to see you again, man.
Great seeing you, Ryan.
Let's catch up sometime.
And all of you. Take care, gentlemen.
See you, Joe. Good Shabbos.
Good Shabbos.
So we've nailed that to death, and I think we've fought about that as long as we can.
What the issues are. It was a very, very good colloquy. I'm very proud of it.
No, I'm and it's interesting because just imagine we're fighting this. Just imagine the people in court whose lives are on the line who are fighting this.
The title of the video can be somewhat laid back law.
Eric, do you mind reading these super chats because I'm blurry, so I can't really.
Yeah, no problem. We'll run through these as best we can. Nate, MAGA country, a church religious space is not a regular public space. It's a listening space, and you may be granted a limited permission to speak, church whisper, etc. Speak forever. I think the argument is that yes, it's a public place until they make a determination otherwise. So they can walk in there, it's a public place, which they did, but then when the pastor said, please go, we've lost the public place. It's limited, right?
Well, just no, it's not. It's still a public place, but there's what's called time, place, and manner. So, for instance, courts are public places, but there are time, place, and manner. You can't just scream in the middle of a courtroom and stuff, so forth.
Actually, no, it's private. Hold on, I take it back. It's actually a private place open to the public. Would be a fair statement, right? Because a courtroom would be a public place, or a
open to the public
would be a public place, but a church is not. It's a private place open to the public. Maybe I used the wrong term. Sorry.
But if the establishment, private or public, are open to the public, there are standards that which they can say. You can't, in the library is open to the public, but you can't raise your voice, even to the private library, so things of that nature. So you're really looking at time, place, and manner restrictions.
No shirt, no shoes, no service. Let me see. My renal MD. I may not read all the screen news because it's hard to. Donald Trump is gagged. The left celebrated that gag and gave legal justification. He didn't get ACLU protection or denunciation. That's true.
That's a great point.
And there's a lot of hypocrisy.
Yeah.
First to admit that.
I would urge you to support FIRE if you're a free speech person these days. They're the true free speech organization that remains.
You got ADL's pretty much garbage now. ACLU's pretty much garbage now.
They do interest advocacy rather than pure free speech advocacy. So if you're a free speech person, support FIRE.
Agree. Stop treating Christians as second-class citizens. Why does their First Amendment not matter? Why did I fight for the Constitution? Nothing I did matters. Wasted my blood, sweat, and tears. No, it does matter. That's why the feds are pushing for charges, is because they do care about the First Amendment rights of the people practicing their religion in that church.
And right? Justin, all those other people, they got in spades, right? They got the conspiracy. Those other people, like the lawyer, they got her in spades. She's going to jail. It's Don Lemon that we have the issue with. The other 6 or 7 people that they arrested, they got them. So their constitutional rights are being protected. People are being prosecuted.
All right. Let's see here. How does the pastor trespassing them and their refusal to leave not serve as a predicate for intimidation? Hell, a woman broke her arm fleeing.
Yeah, so you have to look at each defendant individually. I would assume everybody understands that, right? Don Lemon, as an individual, what did he do versus what did all the other people in the group? There are people, everybody else is being charged with crimes based on those actions. So
well, hold on, he's kind of a weird spot because technically all the other ones could fall under, if it's a felony, the felony clause, right? So if it's like, well, one particular person caused the broken arm, couldn't they all be kind of rolled in with that because they're all committing the felony together? Like if somebody, God forbid, died in the encounter, wouldn't you have a bunch of felony murders for all of them, even though only one person might have actually done the murder?
Yeah. So what you're looking for is you're really talking about a co-conspirator. And
right. And it is a conspiracy, right? The Klan Act.
I'm assuming.
Yeah.
You'd have, but then it goes back to all those other people who were in the conspiracy. But the argument we were making was Don Lemon part of the conspiracy.
Right. He's somehow being cut out of the conspiracy.
Yes,
that's the tricky part.
Because the legal question for the conspiracy is threefold. Did he have the intent to commit the crime in that place? Did he have the agreement? 2 or more people, did he come to an agreement? And then the third, was there an overt act? Yeah. And the court is saying those 3 things are missing, particularly with Don Lemon and not with these other people. So that's the tricky part here.
Well, because conspiracy is in many ways a thought crime, right? Like what you're trying to figure out is whether or not you actually agreed to conspire to commit the offense. And he, that's his defense, is that he didn't make that agreement, which is, I guess, what we'll see litigated.
Well, conspiracy is weird anyway, because I didn't agree to kill him. Phil killed him. I didn't agree for that. Yeah. That wasn't I had no agreement whatsoever. Well, sorry, dude, you were robbing the bank.
Yeah, exactly. So the agreement is to rob the bank, and all the actions that happen because of the robbery, you're now involved with because you agreed to rob the bank. In Don Lemon's case, did he agree to go in there and protest, or did he agree to go in there and cover the protest? If he agreed to go and protest, then if somebody died, everything that happens criminally, Don Lemon could be charged with. But if he didn't agree to go and protest, he just agreed to cover it, then he's immune from all those other things everybody else did because he didn't agree to that. So that's why it's really important what did he agree to and what was his intent? And if I'm wrong, any of you guys can definitely.
No, and that's why the government put
all
those allegations in that he was doing operational secrecy, like he was turning off his camera and walking away to help them get away with it, because that tends to show. Because to Eric's point, obviously they're going to say I didn't agree to that, so you have to prove it through circumstantial evidence. So they're going to say like, what's the evidence that he was helping them and agreeing to help them versus the evidence that he was just there as a reporter, and that's kind of that's the factual question that gets fought out.
All right. So you can violate First Amendment rights of white Christians is what Don Lemon's argument basically is, just dressed up.
I mean,
People are people forgetting that there was all these other people who are dead to rights and are probably going to go to jail. Like there's a whole contingency of people.
I mean, I don't know if they all are,
except for Don Lemon, huh?
Like I still don't think they all are. I still think a lot of them they're going to be. It's going to look like it's going to look like Venice Beach in the summertime. People just skating by.
All right. What happened to church being a sanctuary?
Well, that's true. Same
question. Let me see. Justin, I think Kelly needs to BTFO, the executive branch. Separation of powers works both ways. Again, that's a tricky one because Congress has every right to sit there and criticize virulently the executive branch if they want. Last time I checked, that I don't know.
He is part of the legislative branch, so it's. But again, the judge pointed to that as one reason why you couldn't do this to him, because you'd be essentially it coached it, which I'm not convinced with, but the judge essentially coached it as you're interfering with Congress's ability to execute their political power.
All right. He's still referred to as general, which means he's bound to military. He's referred to as colonel or captain, I believe, not a
captain.
General.
Yeah, he's not a general.
I don't think he ever made general.
And
by the way, it would be admiral
kind
anyway,
that
because
kind
that
of
would be a
credit.
Navy background.
Yeah,
Don't give him that kind of credit.
I've got to bail. It's been
All right,
incredible.
sure,
It's been
Ron.
relation to reality. Catch you all
Hey,
later.
Ron.
Have a good weekend.
Nice to meet you, Ron.
Same here.
A nice Shabbos.
As a soldier, he has a right to speech as long as his superior grants it. I'm
Not when you're
I'm
retired.
hard disagree on that. So
Yeah.
anyway, sorry. Anyway, MSP game. Like if he sat there on Instagram and he was in uniform, we got a problem. But even that is a little bit shaky, and some of the other issues. Anyway, MSP games. My dad is retiring from Teamsters this year. He's not allowed to work in his field for the rest of his life without permission from the union to maintain his private pension, even outside union shops. Well, that's a private pension.
Yeah.
I believe he
He's
signed
agreed
a
to.
contract for said pension that states all of that. So that may
The
be
bargain
true.
for exchange.
And private parties have they can contract with you away your civil rights, where the government's a lot more restricted from these type of
Also, the
blanket
teachers will break your
contracts.
legs.
All right. A manifestly unlawful order is one so obviously illegal that a reasonable person, a man of ordinary sense and understanding, would immediately recognize as unlawful. No deep legal analysis. Well, that's
what
I
Eric
was
was saying.
arguing. Whatever.
I think Nate was right. I think we actually all kind of stealth agreed on that.
Yeah, but the argument came to the word Eric, because this is funny. Eric said obviously, and Joe's like manifestly, and it's like, well, I said manifestly, and then he defined it as obviously, and Eric is like, yeah, exactly what I said, but it's not what you said. I was like, oh my god, you got the most same thing. You just use a different word.
This is why people hate lawyers.
Yeah.
Well, no, I was trying to speak from the soldier's view, because I and that's what I'm saying. I'm a soldier. I'm not going to go, oh, let me get the legal terminology. All I have is you can't do that. You can't do that to somebody. We'll go talk to 100 people down the street. You can't do that to somebody. That's my argument, is that is what a soldier understanding would be, not a legal term.
And then there's Supreme Court cases about, like there was the case, I don't know if you guys remember the case with the law student who took one semester of law and then failed out. And the court said, because he had that one semester, they were going to treat him as he was going to be treated as someone who knew more about the law, so he can interpret the statute, because he was like in a statute interpretation problem where he interpreted it wrongly. But they were like, well, because you went to law school for at least a semester. But a regular person who hadn't gone to law school would have been given that peace. So you're right. As a soldier, they haven't gone to law. They don't know all this stuff, and they're going to be treated as such.
Meanwhile, Sean and I spent like 2 hours on a case recently that turned on whether applying for application to the country is somehow different than seeking application to entry to the country, right? So like, yeah, this is what lawyers do. We just like find these tiny little.
By the way, I disagree with the Supreme Court on the basic argument of, remember, Your Honor, I failed. Think about it for a second. It's like,
how good could I be?
Right. I mean, that should be proof that I don't know my ass from a hole in the ground. I'm worse than a civilian. I was given training and I failed out. That's not fair. Anyway. Tell that to the soldier who was prosecuted for sedition for refusing to wear a different country's uniform in Kosovo. I don't know that specific case, and I just don't know the case. That's weird. Let's see. What Enlisted Joe is a constitutional scholar to determine whether it's illegal or not. They will rely on their officers. The seditious six said enough, but left the rest out to keep out of trouble. And that's what Sean is saying, and I kind of agree with that. They treaded a line pretty tight, and yes, every implication was there. It was a total wink, wink, nod, nod, and a deliberate maneuver, but I don't know if that's illegal. Unethical? Hell yeah.
Oh, yeah.
Unethical, disgusting, despicable, scumbaggery, all that. But illegal? I don't know. Anyway.
Agree.
See United States versus Hewitt Vaughn, 43 MJ 105 114. It literally spells out the standard for you.
It did, but we I left. It was early when I spelled it out. That's one of the cases where it says obviously, and it goes through it. So yeah, that person is definitely right. I can pull it up again, but it's easy.
No, I'll take your word for it. Minnesota National Guard stated they would refuse any orders from the Trump administration. Well, then they would be facing potential trouble. You can't just, again, I never said, and that's what really irritated me, was people were putting my claims and changing the context. And I don't think that's fair. I didn't say, oh, just disobey every order because you don't like it. And that's kind of what I felt like people were doing. I was saying
this is what I thought you were saying, obviously, Eric, because I wrote it down. I typed it out because I was like, I think this is what Eric is saying. So tell me if I'm wrong. Okay. Orders are presumed legal.
Yes.
The service member can refuse orders that are obviously unlawful because you change it from illegal to unlawful. And you say obedience to orders is not a defense to war crimes. So
correct.
Because you brought up the war crime. So that's the law. And I think Joe was saying the same thing, but just saying it in different words. But that's the law. So that's what I thought you were saying. So is there any disagreement with that?
Yes, that is what I was saying. And I was saying that that just saying illegal, unlawful, if you're just pointing out that you don't break the law is essentially what he was saying. Don't break the law. If somebody tells you to break the law and you know you can't break the law, that's kind of all I was. Anyway, that's that's essentially what I was saying.
The only thing I'd say, if people are debating this with their friends at home, is that when I've seen people, like more left-leaning lawyers argue this point, like Pete or other friends, right? The war crimes thing, there's a little bit of sleight of hand that gets played with it, because they'll say like, well, would they have to refuse an order to commit a war crime? And the answer is clearly yes. But if it was obviously a war crime, it would be unlawful, right? The question is it obviously a war crime? So, sometimes the war crime label is used to get around the presumption of lawfulness of an order, right? But if you say blow up the boat, it is not at all clear to a soldier whether there's constitutional authorization for that. And calling it a war crime doesn't change that analysis.
Well, okay, war crime obviously escalates it to a whole degree, but I could say, okay, I want you, we're having a competition between two companies and we're raising a lot of money. I want you to go steal the cash bin from that company. I want you to go to that company, and I want you to just grab that cash bin and you bring it back here, and you're going to put it into our cash bin. That's an illegal order. Okay, it's not a war crime. It's definitely lower, but I know damn well. I know what happened. I know what we're collecting, and I know that this is illegal. I'm stealing from one unit to do this, if I'm stealing products from one unit to another unit, and that soldier would be prosecuted as well as the person giving him an order. And this does happen in there. So that is essentially what I'm saying about that. And yes, I use wartime because it's easy and wonderful, to go to that high level. But if it's obviously unlawful, and it, I guess it's like the definition of pornography. I know it when I see it. Now, as far as the other bit, people, and why I'm sensitive about it is there are people in the military who are called shade tree lawyers, and they are the ones who will try to parse everything out. Well, regulations, it's like, whatever. Then you go ahead and disobey and see what happens. So there are the two levels to the whole thing.
I do think with this analysis, we failed to mention what they were saying is illegal. So they're saying that the boats, if you have clear evidence, the boats, they're unarmed, they're just fishing boats, and they're in the middle of those, and they say, okay, these unarmed people who are on fishing boats, we know the intel, blow the boat up because we want to make a statement. That, they were saying, is an obviously illegal order.
Oh, I don't want to get into that one right now.
That's essentially what they were saying. So in other words, it's saying those boats say you're not illegal. Now, I agree with Ryan 100%. If you're in the middle of and they're saying blow up that boat, then I think you're in a real tough spot if you're trying to say that's obvious.
Well, here's the here's where that all breaks down, Nate, is if you're given the order, you're sitting there, you're the person, you hit the missile, and they say, go ahead, fire now. That's your order, and that's all the knowledge you have, is that you have a target and you are firing. That is 100% of your information.
That's all you need. Yep.
You're covered. You're covered because with the information, you have a presumption, and I think that's what you were saying, Ryan, of
100%
that the lawyer, that this is lawful. No, it's lawful, right? Now, if you happen to know the owner of the boat and you know for a fact that this is not a drug boat, that this is actually a family who's on a fishing trip, and I'm not going to ask how you get the knowledge, but if you do know that, now it's an unlawful order because you do have that extra knowledge. So I think that's where the part comes in. It's like, if you know somebody is unarmed and they are saying, I surrender, well, you just committed a war crime, correct? It is now murder. But if you say fire on that target, and you fire on that target, and the person happens to be unarmed, but you don't have that knowledge, you were given order to just fire on a target. Now it's a different scenario. So they're both the same results, but one would be unlawful and one wouldn't. One would be prosecutable and one wouldn't, in my opinion. Am I speaking in tongues? Or
no. I think you're right, and I think there's actually even layers of complication above that, right? Because the first question is the president authorized to use military force in this way at all? If no, then you could make the argument this isn't governed by the law of war. This is just murder, right?
But the soldier doesn't know that. But the soldier in that case is just a weapon.
Exactly. Yeah. I would say the soldier has no possible way of knowing that. So that's layer one. Layer two would be what you just said. Do you have information to suggest that this particular strike is illegal? And then layer three would be the double tap scenario. Did you learn information during the course of the operation, which arguably could make it illegal at a certain point? If the boat was disabled and went out of combat, that sort of thing. So there'd be multiple layers of the analysis, which we were kind of conflating just to speak a little bit more high level. But yeah, it's very complicated. I also think it's hideously unfair to ask soldiers to do that kind of analysis, while being told, push the button right now. They got 2 seconds and they're supposed to do some kind of deep constitutional
right. And 90% of the time, or 99% of the time, probably actually at 999 out of 1,000 or more, push the damn button. I absolutely agree with that, but there's a nuance in there.
Yeah. No, I was gonna say, just once again, it also goes back to the whole idea of, is it legal? And remember, you just saw 6 congressional members of Congress saying, we're going to flay you alive if you get it wrong. And they're promising to come after you.
Well, and that's they're assholes. I mean, and
yes, they are.
And they're wrong for that. And by the way, they should be censured. by Congress, which of course I don't think they were. And who's in the majority? Which party's in the majority? Aren't they the same as the president, but they can't manage to censure these people? Or I don't know. It's very confusing to me. But anyway, let me see. The whole arguments here illustrates that we don't know the point. They want confusion. I agree.
I agree.
But and tie goes to the runner. And in criminal law, tie goes to the runner always. Matter of fact, I would even say you have to have overwhelming to win. So in that case, if that's true, then Mark Kelly should win.
Anyway, let's see. Wellesley, Eric, service member, just illustrates the conflict of interpretation and what the law says. Confusion. Oh, okay. Yes.
But you weren't confused. That's the
problem. I don't think I was.
The law says this. I interpret it as obviously illegal. And then it went to shit after that because it was like here's what the law says. It's got to be obviously illegal in there. So, but
well, I felt like words were being put in my mouth, and that's why I was getting frustrated.
I think it might have been my fault because when I was reading the law, I didn't say manifestly, and then when Joe said it, that's why I went to look at the case law and said, he's right. It has to be manifestly, but it defines manifestly illegal as obviously illegal. So it's kind of like you just use you saying it's synonyms, but if you didn't use the correct word that was used in the damn case, then it was
because I said it from the soldier's perspective, and I even define that saying the soldier doesn't have the words for that and doesn't have that knowledge. Go around and talk to them.
And actually, Nate, you just said something I think is really interesting because it actually crystallizes for me why I got so mad about those statements in a way that I hadn't thought about before. When the Congress people are prosecuted, they get the benefit of being a defendant. Tie goes to the runner, as you said. But if the soldier takes their advice and does not follow an order, they don't get that benefit. It's actually the other way around.
Tie goes to the government.
They have to prove the order was unlawful. So they're asking the soldiers to take a risk that they themselves are not taking. That's what pissed me off about it. And I hadn't really thought about it in that way until you said that. But
You're right.
That makes a really dirty pool.
And Candace Owens has done that too, telling soldiers that they should desert or whatever, with other terms. Yeah, I totally agree with you. And by the way, those of you or people who are asking, well, why is it that the tie goes to the government and not the soldier, is because a soldier not following the order puts other soldiers at added risk. And that's why the tie doesn't go to that soldier. Well, and it breaks down to discipline. It breaks down this. Also, a soldier is not a civilian. A soldier is an indentured servant. I know that sounds terrible, but you actually are an indentured servant as a soldier. You sign a contract. You are government property. And it is a weird fact. But
and the tie goes to the soldier if they follow the order. It's presumed lawful. It's just that if the soldier is saying, I'm not going to follow the order because I think it's unlawful, now the soldier has to prove it was unlawful, right? It's not like the soldier gets the benefit of the doubt then.
Yep. Let me see. Nate, there isn't a duty to disobey the illegal order. There's a protection if you disobey an obviously illegal order. So orders are presumed legal. That's not true. If you commit a war crime, you can't say that it's just following orders. That is not true. There's Vietnam case. There are many cases been prosecuted on that. No, if it is obvious and you still do it, tough shit, you're going down too.
Yeah, I want to be very clear. We definitely looked at the Uniform Code of Military Justice. Every time it says order, it says lawful order. It doesn't just say orders. It says lawful order, lawful order, lawful order, lawful order. So, can you bring that super chat up again?
It's already gone, dude.
But the only issue I would say is the presumption. The officer, I think, is in a worse position because if the order is obviously illegal and the officer follows it, the officer will be prosecuted, right? So you definitely have to think about that. But then, so it's not the way the super chat made it seem like if you follow all orders, you're not going to be covered. But that's not true. If you follow orders that are obviously unlawful, you're not going to be covered. It's on you.
Not at all.
So there's an evaluation that has to be done. But the presumption, if it's close, follow the order. Argue it later. close, follow the order.
Or not even close. Just unless you know it's obvious. You know, again, that's where the obvious comes in. It's like, again, that's why I said 999 out of 1,000, you know, or whatever, even a higher number. You just follow. You're just gonna follow. You're just gonna follow. Just gonna follow. But if it's like, no, and then you should at least question it, and then that's where the conflicts get in. But anyway, was the judge just afraid of the heat? I don't know. Good question. Holy cow, there's more super chats rolling in. Anyway, I do appreciate that. I like this. Scumbaggery is now part of my vocabulary. Refreshing debate, gentlemen. Thank you, Maddie. I always try to educate on the streams. I like that term. I think Nate likes to use scumbagging them too as a thing. Let's see. This is why the Westphalian standard was better. Soldiers are tools of the state. Trying to burden them with snap determinations was ex post facto. Victor's justice.
Well, you got to think the Germans. The Germans with the whole "we're following orders" always to Nuremberg. So you know that just doesn't work. You know, it's like, you can't just do that.
You know, despite what he said, the Treaty of Westphalia did a lot of good things.
Yeah.
Let me see. This is saying, in the U.S. Navy, we are not fully retired until 30 years of service and still accountable to the UCMJ. No 06 knows this, but hubris is a B.
Yeah, but again, I think we also have to understand the hierarchy of laws here too. There are some constitutional rights you can contract away. There are some that you can't, especially the government on the government side. So freedom of speech could be contracted away, but it's still limited. The government doesn't have, can't just say because you're in the military you have no rights when you leave. And that's what even what you just read, you said it had to be for good cause. And now that'll take us to a whole good cause analysis with that.
Exactly right. Like what is good cause?
Yeah, what is cause?
How does the First Amendment factor into good cause? Right. That's going to be a question. How does the protections that you want to give to the members of the legislature factor? Like there's going to be all kinds of separation of powers, First Amendment issues that would limit what good cause might be. And I don't want to pretend that I know enough about military law to weigh in on
that. Very true. It's frustrating when you and another person are arguing for the same point and you realize that is happening, but the other person doesn't.
They're talking about you and Joe arguing the same point.
No, that's a hypothetical. Has nothing to do with this channel. That seems unrelated to anything that happened today.
The cell was autocorrect. Orders are presumed legal. You get protection if you disobey an obvious illegal order.
Correct.
Again, no duty to disobey exists, or tie goes to government and military law.
You keep saying there's no duty to disobey. If you
that's not true. You have an absolute
code
duty.
of justice. You only have a duty to obey lawful orders. Every time it says obey orders, it says lawful orders. You do have a duty to disobey unlawful orders.
Yeah,
that's why they make it very clear in the code of military uniform code of military.
I think you have a duty to disobey manifestly unlawful orders.
That's correct.
Yes.
Yeah. And then somebody said, "Need I say my lie?" Yeah, thank you.
Yeah.
Abu Ghraib. I mean, again, so it is. And yes, okay. And Michael Stetson, but all orders are presumed lawful. Yes, they are presumed lawful unless they're obviously not.
Which is a hell of a thing to leave out. That is a hell of a thing. Like, when you're saying, hey, wink, wink, nudge, nudge, you don't have to follow unlawful orders. All lawfuls are presumed lawful. Like that's a big thing to leave out. But okay, I think we covered that.
Right. But even
that's
the
how they can say it
UCMJ.
without breaking the law.
Well, that's why I was frustrated when he was like, by his not including that word. It's like, that's not true. I mean, just saying, don't, it'd be like me walking up to somebody saying, don't follow unlawful orders. Okay.
Cool,
it's kind of redundant. It's sort of redundant. It's like, yeah, okay.
Don't drink and drive.
Right. Why are you saying that? And I get that. That there's obviously an intention and nobody's questioning that.
Yeah.
It's just
but it's
frustrating.
But now it's like saying, don't drink and drive, but I'm going to come back later and I'll make a determination if I think you've been drinking. So you better be careful. Like, that's where it's like, you better not break the law, but I get to determine later whether or not you broke the law. It's like, how the hell do you comply with that?
Well, and this is a great point here. Minutemen in the silo are purposely left in place with almost no information. Yes, because that is a fantastic defense. Because as I said about the boat analogy, which is kind of on point, if you're sitting there and your job is acquire a target and fire the freaking missile, it is not to determine the cause, is not to determine anything. You are nothing more than the missile. You are an extension of the missile. You are a weapon. At that point, you have no knowledge one way or another. Your job is to perform an action, etc. Now, if you do have that knowledge, that's where you get in trouble. But if you don't have any kind of knowledge or whatever, that is presumed a lawful order. Or if you have no, and even if it was unlawful, let's say it was completely illegal, but you have no knowledge of that, well, then you're still technically not at fault, in my opinion. And I don't know, you guys can correct me if I'm wrong on that.
No, you're right.
It's actually kind of funny. It reminds me of I don't want to say for every state, but in most states for lawyers, if you look at our ethical rules, we're required to report illegal conduct by another lawyer, but only if you know it's illegal. And if you look at the case law on this in most states, a lot of it comes around to like the levels lawyers will go to make sure they don't know for sure something, they walk in the bathroom, they're like, oh man,
the lines of cocaine.
Yeah, Nate, it's so weird that you ground up your Altoids and you're snorting them off that bath. That
like, I didn't know.
It's so I clearly see the Altoids. It's really weird, and I'm gonna leave.
That woman you're having sex
anything.
with just must be a doppelganger for your client you just met with.
Your wife's wearing a wig?
Yeah, what a striking coincidence.
Yeah,
Nate. Sorry, Nate, that you're the example. Yeah, because we can go out of our way to not know anything. So
all right. Well, you know what? We've ran almost an hour longer than anticipated, but I hope everybody's enjoyed it. Ryan, do you have something coming up?
Yeah, well, first of all, thank you to this channel. I'm sorry I joined late. I had to, get that brief off my desk before I could do anything fun today. But you guys have been tremendously supportive. Got some new videos coming out. Got some great advice from Nate that I'm struggling to implement, but I'm working on it. So thank you for stopping by my channel, Natural Law with Ryan Mullally on YouTube. Look forward to seeing you.
Sean.
Trying to wrap up some things, and then looking at this case called Edric Faust. It's down in Georgia, and it's a very interesting case. Like, he's being charged with murder, and apparently there's so much goofy stuff going on. Like, there's been more than once where the detective is like opening up an evidence envelope and goes like, I guess there's nothing in here in this case already, once or twice. So I might be looking at that coming up here to take a look at that. And then also tomorrow, I'm going to look at the Alec Murdaugh. He had his arguments for the South Carolina Supreme Court. And it sounds like a lot of interesting stuff was discussed. Whether or not he's going to get his murder conviction overturned to get a new trial. At the end of the day, it doesn't matter because he's doing like 1 million years for stealing all the money. So, but we'll take a look at that. I heard it's very interesting. So that'll be tomorrow.
All right, fair enough. And by the way, this is a good point by Jerry Cron. This is enlightening to know just how little people know about the military. Part of the reason for that is there are only, I believe, 1 million people plus in the military out of 360 million people in the country. So it is an incredibly small minority of a minority. There are many people who never even run into an active duty member in their entire lives in the country. I live in an area that's saturated with military everywhere I look, but many other parts, you barely see anyone. Hardly at all. And I grew up in Tucson. There's an Air Force base there, and I didn't run into really many military at all because I lived on the other side of town until later in life. So I think that's part of the issue. Is military is really, really an extremely small minority, and people just don't realize that. But Nate, what do you have coming up?
I got a update. I'm sorry, guys. I'm just not all here right now.
That's fine, dude. He's having a tough day.
So first I thank everyone. My video I put out this morning has gone viral, so it's doing like amazing. I appreciate everybody who's watching those videos. I'm like, wow. I have a Tiffany Hinyard update coming up, and I wanted to look at some more cases, but I think I'm gonna have to pull back a little bit because I haven't been feeling it for the past like week or so. And I want to thank for the Today Show. Is actually they interviewed me because of the whole brain tumor thing. I didn't know how crazy it got. So the the reason why they interviewed me, the woman said, is because they were on X, on the NBC Today Show people, and my situation kept coming up in their feed. So they're like, we should interview this guy. Who the hell is this guy? So they interviewed me. That should be coming out. I'll be sharing that. And otherwise, I think I'm going to be taking a little slower. I love these chats, and my goal, and one thing I do want to do is I've always been one of those people who always want to help the LawTube community become bigger and better. So so hopefully you'll start seeing me do a lot more collabs with a lot of the people here. Me and Ryan are planning something, and I would love to come on Sean's channel again, but he doesn't really invite me too much anymore. So but no, I'm just
have you on, Nate.
Yeah, but so hopefully, I always say we all grow together, and I honestly really believe that, because I don't believe I would be in a position I'm at without Eric, without Viva, without Joe, because we all kind of support each other, and I just hope that we can continue to do that in a meaningful way. So with that being said, thanks you guys for watching, and hopefully you'll be back next week, because we're going to do it again and yell at each other and still leave as friends. So
there we go. And all right, I'll wrap everything up. I have another show today on America's Untold Stories, so people want to check it out. But for a final word, I'm going to leave it to Judge Judy on the way out.
All right, you're in my courtroom now, Buster. And let me tell you, there's so many of you here that are downright guilty of not subscribing to laid back law, yet watching full-blown episodes. Why don't you get your life together and just hit that button already? We all know you need it.